We are fraud, committed any fraud.
Great. Next.
But I am appearing for the petition.
My lord, I appear for the respondent number 2, my lord. I am appearing virtually today, my lord. There is no scope of any interim order in this matter. I would like to file an affidavit, my lord.
My lord, I have not started the matter. Let my learned friend have the patience to wait. Obviously, there is a scope for interim order. I'll tell you why, my lord.
But I beg to for the regulatory commission.
My lord, just allow me, before opening the brief, allow me 3 minutes of my lord. My lord, this matters relates to the tariff period 1718, 1819 and 1920. 1718, 1819 and 1920. My lord, two sets of litigations was proceedings. One, my lord, before this Honorable High Court and the other before the Appellate Tribunal for Electricity. Although the issues were different before the two forums, but the proceedings were, my lord, contemporaneously running. 1718 tariff order is 5th May 2022. After 5 years, they had published the tariff order for 1718, saying there are area charges. One of the consumers, including this present consumers, approached the Honorable High Court saying that truncating of one single year of tariff period is without jurisdiction by the Regulatory Commission. Initially, interim orders passed. All interim orders passed, saying no coercive stays against the tariff order dated 5th May, area charges. Well, the same orders were passed in APTEL also. APTEL goes one step further. By a 1st July order, they said, irrespective of parties coming to my court or not, because tariff is a order to be passed in rain, it will be applicable, my order of injunction will be applicable to all consumers across board. Well, ultimately, all these orders, APTEL modified the order for 1718, this on 17 January 2025, saying no, the consumers are leaving the licensee, so 50% has to be paid and the 50% has to be deposited by way of security as bank guarantee. So, my lord, from 2022, the interim orders were proceedings for 1718. It came to a halt, if I can say. APTEL said 50% has to be deposited and 50% has to be secured by way of bank guarantee. DVC files an application before the Honorable Division Bench. In the meantime, my lord, our writ petitions get dismissed. Division Bench admits the appeals, says the interim order that was prevailing before the Honorable Single Judge would prevail also. This continued till 17 January 2025. Thereafter, DVC comes up and files an application. Our division bench modifies the order. To that 50% has to. There are subsequent modification also. Then, my lord, some of the consumers approached the Honorable Supreme Court, including this consumer, where further extension was granted. And admittedly, 1718, 50% was paid by my client. There is no dispute. I could not pay the 50% security deposit despite there being an order of Supreme Court, but I could not avail within that time period. In the meantime, 17 June 2022, another tariff order came. This is for 1819 and 1920. This was also a subject matter of challenge. This continuing interim orders were passed on 11th August 2025 for 1819, 1920. Interim order, the APTEL again modified the order, adopted the same policy, 50% deposit, 50% by way of bank guarantee. Immediately, and the APTEL also clarified the consumers who are not before the APTEL will not be given this benefit. Immediately, we receive a disconnection notice. We approach the Honorable High Court. The Honorable High Court adopts the same thing, says 50% to be deposited, 50% by bank guarantee. But we could not do it. There was a disconnection and suffering the disconnection. Now there is also a termination. In the meantime, another batch, which I was not a party, was going before the another Honorable Coordinate Bench, single bench. This 18, 19, 20. There was a stay order for area charges for 18, 19, 19, 20. Which got modified on 18 September 2025. Some of the consumers approached the Honorable Supreme Court. Honorable Supreme Court says no further area charges should be recovered. This is the order passed on 23rd March 2026. The state is 1718, 50% I have paid, 50% I could not secure. Another group of matters which Supreme Court is pending the month of January. The matter is to be scheduled. They have got a protection of 27. Yes, Malad, that is the date given. Now, why, Malad, this interim order was Supreme Court was passed. In the meantime, an order was passed by APTEL that all the consumers for the period 9 to 14 will get refund. All the consumers, and WBSC has given a calculation, if I'm not wrong, about 450 crores is repayable. Exactly, I do not know, but some amount has been mentioned, 450 or 250, I'm not aware. It is not recorded. So, but if it was asked for the Supreme Court, yeah, what amount the consumers are entitled. In their premise, there is a stay. Initially, as I could not comply with the order of the Honorable Single Judge against the 1820, 1920, I faced a disconnection. I went up to the single bench for an application saying kindly extend the time period to comply with the direction. Honorable Single Judge says no, there is a subsequent developments. These developments cannot be considered in a you have to file a fresh writ petition. I have come to a fresh writ petitions. I will show some of the orders just for my lord's convenience. This matter now relates to 1819 and 1920 and some part of 1718. My lord would kindly see page 353.
Yes.
I tender apology. Would kindly see first 345. A tender apology. Just
345.
yes. Second paragraph says the petitioner challenges the order dated 12th August 2025. This is the disconnection notice. 2025. Now, my lord, kindly come to the next page. 346. Learned counsel for the petitioner has drawn attention of third paragraph, my lord, of this court to an order dated 11th August 2025 passed by the Appellate Tribunal for Electricity, wherein certain other consumers have obtained the following reliefs relating to the area dues for the said control period. For the aforesaid reasons, the interim order passed by this tribunal on 27 July 2022 is modified, and there shall be stay of areas insofar as the appellants herein are concerned, on condition they are 50% of the areas as determined in terms of the impugned order of the WBSC and furnished a bank guarantee for the remaining 50% within 3 months from today. They shall also continue to pay the current dues in terms of the order impugned in this appeal. Needless to state that this failure to comply with the aforesaid order would result in automatic vacation of the interim order now passed in so and so. This was disposed of. This was adopted by the Honorable Single Judge. Would find 348 second paragraph. This was adopted by the Honorable Single Judge.
Yes.
Yes. I could not comply with this. Admitted position. I had written letters to the DVC saying my financial condition is not good, distressed. I had also written to the authorities, GST authorities, saying my business has stopped. I'm not in a position. I'll come to that. Those letters. But kindly come to 353 P19.
53.
The order was passed by the Honorable Single Judge on 27th August 2025. Now 353. The second disconnection notice. This is to bring your notice that Damodar Valley Corporation so and so, vide its notice dated 12th August 2025, had directed your organization to clear the outstanding areas amounting to so and so within 15 days from under section so and under clause so and so of the supply code, failing which your electricity supply would be liable for disconnection. Subsequently, the Honorable High Court, by its order dated 27th August 2025, in so and so granted temporary protection from disconnection strictly subject to the following mandatory compliances, which is as follows. I'm not quoting the same, your organization reached, so on 12th August, I suffered a disconnection. Now, my lord, in the meantime, my lord, page 370, my lord, for my lords, I'll show the order. I had approached the Honorable Supreme Court after certain arguments. My lord, Honorable, we had withdrawn the matter, saying that whatever you have to argue, you have to go before the Honorable High Court. I'll show that order. My lord, page 370.
You have gone before the Supreme Court without going to the division bench.
My lord?
Directly from the single bench.
Yes, yes. We respectfully submit that our 370, my letter, post disconnection. We have the above mentioned, we hereby request you to kindly arrange for the reconnection of the same at the earliest to enable us to resume our factory operation. We like to inform you that you are willing to pay 50% of the outstanding dues pertaining to the period in 3 installments. The remaining areas are currently upon consideration before the Honorable Supreme Court and also pending before the Honorable High Court at Calcutta. We undertake to pay the same as per the final judgment. We said this. Due to adverse market condition, so and so much, page 370. Now, my lord, kindly see the termination. I'll come to the orders vis-a-vis the orders passed by the Honorable Single Judge Coordinate Bench, 375. Now, this is the termination, the second challenge before this court. This is to inform you that power supply connection at the factory premises, a power purchase agreement was executed between DVC and so on 29 July 2015. Subsequently, due to non-payment of energy bill, Supersmelt Industries Private Limited was disconnected on 2nd December 2025. He quotes 23 thereafter. That since more than 180 days has elapsed since disconnection of power supply connection and no intimation for reconnection, restoration of power supply connection has been received from your end as per clause 23. Well, pausing here for a moment, they fail to take into consideration page 370. My letter they did not take into consideration, which was April, and Manad would find the receipt also. So they did not take into consideration. Now, Manad, we asked what is the money you are holding on account of security. Manad would kindly see, come to page 378.
78.
Yeah, 378.
Yes.
Manad, finally, Manad, balance is 10 crores something. 27th July against 27 July 2025, the security deposit, and 41 lakhs is the interest in respect of such.
It's 378, balance is 12 something.
12, then it goes to 10. Thereafter, the interest has to be added. It will be about 11 crores. Just pausing here for just Honorable Single Judge had relied upon the order of 11th August 2025 for passing the interim order. Subsequently, that order also gets modified by APTEL.
By APTEL.
Subsequent, these are all subsequent developments. Kindly come. I'm just page 1. This is 381. This August, the order passed by the Honorable Single Judge. Thereafter, the subsequent event starts to take place. 15 September, page 381.
Yes.
My lord, kindly see the order 15 September 2025. My lord, here the consumers order passed, the consumers will be entitled to refund. And my lord would find the last page I am showing, the ordering portion 442.
442.
Yes, my lord. Well,
Yes.
for the foregoing reasons as stated above, we are of the considered view that the captioned appeal so and so in the batch have made it and are allowed. Accordingly, we set aside the impugned order, remanding the matter to the State Commission for passing consequential orders strictly in conformity with the findings and directions made herein above. Need not add that the matter is pending very long. The Commission is directed to pass fresh orders within 3 months from this date of this agreement. We further direct the State Commission to ensure that the consequential financial impact arising under the remand shall be passed on to each affected consumers of the command area within West Bengal of DVC from whom the excess tariff has been recovered through 6 equal installments, either by adjustments in future bills or through refund in case the consumer is not drawing power from the DVC. The caption appeals are pending, so and so. My lord, now in view of this order, some of the consumers approach APTEL for modifying the order of 11th August. Can you see what happens? My next page 443. That is the order dated 7 November 2025. Now, my lord, the APTEL refused to link both the tariff periods. My lord, 449, last paragraph. I'll show. While we see no justification whatsoever in linking compliances with the interim order dated 11th August 2025 with the outcome of the remand proceedings pending before the Commission, pursuant to the subsequent order passed in the tribunal in appeal number so and so and batch dated 15 September, which I showed, page 442, which starts from page 381. Page 381, my lord, would find the date 15 September. Considering the persuasive submission urged on behalf of the appellant, thus this tribunal should exercise its equitable jurisdiction to extend the time for compliance of the order of this tribunal dated 11th August 2025. As the amount involved is substantial, we consider it to appropriate to extend the 3-month time granted for compliance in terms of this order of the order of this tribunal dated 11th August 2025 by further period of 4 weeks from 10th November 2025, making it clear that the failure to comply with the said order within the extended time of 4 weeks. Such would enable the respondent to have the order of this tribunal dated 11th August enforced in accordance with law. Further extension was granted. So it gets modified 11th August. Both these orders are now subject matter of challenge before the Honorable Supreme Court. Both 11th August, this order, and 15 September. And 15 September, there is a stay on the refund, but Supreme Court has specifically directed the Regulatory Commission to calculate what is the refundable amount. They have been asked to do it. I'll show that order. This is one part of the litigations. Another part of the litigation which was pending from 2022 vis-a-vis this period 18, 19, 22, there was an interim order for some of the consumers. I was not a party to it. I was not enjoying. That gets modified on 18 September 2025. It's very important because this is now challenged Supreme Court, and Supreme Court says area charges will not be recoverable. Now, kindly see this order, which starts 4th volume, 451.
Four five one.
Yes, it starts from 455. I just placed from paragraph 3. Because, my lord, DVC's stand has been all along, there has to be consisting between the orders passed by two forums. If there is an interim order, both the forums should enjoy. If there's a modification, both the forums should have the same orders. Because that was the stand all along. And that's why from time to time, our court has modified in view of the appellant's orders or the vice versa. My lord, would kindly see 455. Paragraph 3. Learned senior counsel appearing for the applicants, means the DVC, in the vacating application contains that the arrangement made in connection therewith in respect of different matters from different fora in respect of the said period would have a material bearing in the present on the present writ petition as well. Similar orders as sought for in respect of the present vacating application. Learned senior counsel further points out that taking undue advantage of the interim order passed by this court, some of the consumers who have preferred writ petitions have been migrating to other distribution companies. To prevent the same, it is pointed out that the different fora as referred to above have also been passing orders restraining such consumers from migrating to other distribution companies in the interim. It is suggested that the consumers who have already migrated, the modification to the impugned order of stay would be to the effect that the stay order ought to be vacated or entire amount of dues ought to be directed to be paid subject to the outcome of the writ petition. Learned senior counsel so and so that some of the entire said entity is one of the most loyals, but ultimately, my lord, 459 paragraph 70.
Yes.
Thus in respect of so and so the writ petition shall remain restrained by an order of injunction from migrating to any other distribution company than the DVC for the power consumption during the pendency of their respecting vacating application. The above writ petitioner as well as the writ petitioners in so and so shall pay 50% of the electricity area charges due for the relevant period, and that is 1819 and 1920 within 3 months to the DVC. My lord, my contention is from 2022, 17 June 2022 was a tariff order for this period. So the one set of consumers were enjoying the interim order. That got vacated or modified to some extent on 18 September 2025. Now, my lord, kindly come to page 464. This is dated 23rd March 2026. Now both the set of appeals are being heard together. One preferred by DVC against the 15 September order, and some of the consumers would find, and the Association of Consumers. Page first line 464, my lord, would find Damodar Valley Consumers Association. Thereafter, my lord, would find the names are not very clear, but my lord, they are parties. Now kindly see page 466. 66, the ordering portion. Now this is dated 23rd March 2026. Mr. So-and-so learned senior counsel submit that a statement indicating that the liability and the credit as obtained between Damodar Valley Corporation and its customers will be submitted. Indicating the liability and credit as obtained between Damodar Valley and its customers will be submitted within 2 weeks from today. In the meanwhile, we make it clear all DVC consumer will continue to pay the current dues without fail. Damodar Valley Corporation shall not take any coercive steps with respect to past dues till the next date of hearing. We also direct the Regulatory Commission to provide the full and correct figures to enable us to pass appropriate interim orders pending disposal of the. So, both the appeals, kindly mark the language coercive steps with respect to past dues till the next date of hearing. My lord, just pausing her for my lord would remember the termination notice was 15 June. I am still a consumer, but because it is connected. Default, maybe a defaulting consumer, I'm still a consumer because I'm connected. That Justice Dotto's judgment, my division bench judgment. I'm still connected with the line is still connected. Infrastructure is very much there. And 23rd March, the Honorable Supreme Court says there is a stay of all the area charges. Now, the second order, next 470, which is dated 4th August 2026. 470. 468 is the date, my lord. 470. Diary number so and so. All appeals are admitted.
What is the interim order that you are expecting?
Well,
Because they
today-
have already terminated the
Well,
power.
today, kindly, my lord, there are
Connected
two, my lord,
the
two
line.
facets. My lord, subject to correction. My lord, today, my lord, if I can show prima facie, the termination is bad.
Termination, if I pass any order,
Well,
it will amount to restoration of termination, which will be.
My
the
lord, I
final
understand that. My lord, that's why I was praying for setting aside of the termination. My lord, whether
But then that
my lord,
again amounts to final.
my lord, my lord, my lord,
But
my
then
lord,
should I do that without granting
my
him
lord, today, my lord,
opportunity
with
to
deepest
opposition?
respect, there is, I am relying on judgments, orders passed by different fora.
Still very
My
well.
lord, there is no
That's fine.
dispute, and I am only relying. My lord, kindly appreciate this.
Because once they are entitled to file an opposition.
My lord, I can understand. My lord, they have. My lord,
It's not
my
that
lord,
it
that
has
will
happened
not
today.
help. My lord, suggestion subject to correction. I'll have given a calculation. I have a calculation. If they agree to it, my lord, kindly see just 470. I'll come to that. 470. Kindly see. Paragraph 4, Mr. Sohan, in consultation with the advocate record representing the State Electricity Regulatory Commission, will file a necessary compilation comprising of the relevant document as also written submission of all the parties in the month of January. In the interim orders to continue. Now, my lord, page 380, I'll just show this, thereafter I'll leave it to your lordship. Page 380.
380.
Yes, 31 volume 3, 380.
Yes.
Manoj, this is without prejudice to my right. I will say why. My disconnection was not based on failure to pay the 1718, the remaining sum or securing that. My disconnection was only limited to not fulfilling the order or not complying with the order of Justice Chonu or the coordinate bench. Manoj, 380. Manoj, kindly see what has now is the calculation. 2016-17 actual demand is 17 crores odd, out of which admittedly I have paid 8 crores. Admitted, is recorded in the Supreme Court order. Deposit date 8th April 2025. So remaining is this. Now 18, 19, 19, 20 is 6 crores. Out of which nothing was paid, so 14 crores is my liability. Out of which 11 crores was lying with them with security deposit. So what remains is about 3 crores exact liability. I am willing to give an undertaking that's subject to the result of the Supreme Court. I'll pay the remaining. Let me run the factory. My instruments, there is, because of this, no electricity, my things are getting stolen, machineries are getting stolen, and whatever I have to pay, because today, I cannot start at a full throttle.
But what will happen to the security deposit? Will get
No,
used
I'll
up?
tell you, for full throttle, I'll have the minimum contract demand. For that, I will have to pay the security deposit, which I'll undertake to pay, or else they should not give. And the remaining 3 crores, let it wait for the result of the Honorable Supreme Court. They will not.
Mr. Datto,
My lord.
you've heard him.
I have heard him, my lord. I am surprised that Mr. Chakraborty relies upon all orders in which his client is not a party. And I will take your lordship through each of the orders. My first and best point, the reason why I said this requires affidavit is what lordship just now indicated to him. He is challenging as an interim measure. He wants stay on termination. My lord, stay on termination here would mean that it's again, my lord, status quo ante, and he is not a terminated or a disconnected consumer. My lord, I was carrying the Supreme Court and my lord, a High Court judgment to support this contention of mine, but since your lordship has already indicated, I will not trouble your lordship. Mr. Chakraborty's client is only governed by one order. My lord kindly takes the order which we started with, my lord, at page 345. This is, my lord, volume 3.
Mr. Chakravarti, why don't you come up after affidavits? It was done in June. We are in August. I'll put him on a short affidavit note so that it comes up on the.
Then, my lord, may I request kindly fix us at any date?
Fix the date. Mr. Dotto,
My lord gives me 3 weeks time.
No,
I
that
will
is
file
the
it in
my lord,
3 weeks.
Mr. Dotto, don't take 3 weeks, take 2 weeks. He'll take 1 week. After 3 weeks, I'll fix a date.
my lord.
My lord, since it's, my lord, the records are voluminous, lordship sees he has relied upon
Records are
4
all-
volumes of.
These are all mostly these are orders, and it's not that you have to make something on disputed questions of fact. So let's have it done. Just because it
My
is.
lord, I just don't want to face an embarrassment before your lordship. I
No,
know
you
3
must
weeks. I will definitely, my lord, file makes it peremptory. My lord, he has waited from, my lord, August 2025 when the first notice.
Mr.
We are
Chakravarti,
in August 2026.
My lord, that takes us absolutely close to vacation. That is the difficult.
it will. We are on 20th, so it will be somewhere near 17th of September.
Yes, my lord.
Dikani.
My lord, BBC stand that they can basically differentiate between the same set of consumers. Whether my learned friend's argument was, I'm relying on judgment of Supreme Court, but where I am not a party.
I don't know why is he
No,
again, my lord,
I do
arguing,
not
my
know
lord.
why DVC, my lord,
Why is he
what
again
benefits?
arguing, my lord?
But a disconnected consumer cannot pay him the monthly rental charges. Only a connected consumer can pay. My lord, I do not know what benefit the DVC will have. For
This writ petition seeks cancellation
চলো আমি যাচ্ছি বলো শুদ্ধতা আছে
of
তো?
the termination notice dated June 15, 2026, issued by the respondent Damodar Valley Corporation, whereby a power purchase agreement between the petitioners and the Damodar Valley Corporation was terminated. Full stop. Paragraph. Having heard Mr. Chakraborty, learned advocate appearing for the petitioner, and Mr. Dotto, learned advocate appearing for the Damodar Valley Corporation, this court is of the view that the writ petition should be decided upon the parties exchanging their affidavits. Full stop. As prayed for by Mr. Dotto, let affidavit in opposition to the writ petition be filed within 3 weeks from date. Full stop. Affidavit in reply thereto, comma, if any, comma, be filed within a week thereafter. Full stop. 4 সপ্তাহের পরে কি ডেট পড়ছে?
17th, my lord, we are reaching 17th of September.
List this matter for hearing on September 17, 2026 at 2 p.m.
I'm grateful.
Grateful.
Full stop লিখে দিন, since the prayers, since the relief prayed for in the writ petition are for termination of a notice of are for cancellation of a notice for termination, comma, passing an interim order at this stage would amount to granting final relief, and as such, comma, no, there is no scope for passing an interim order.
Grateful, my lord.
Grateful.
I thought of saving some time, my lord. That is why I indicated at the first instance.
My lord, appearing on behalf of the petitioner, my lord, to make let me Mr. Shankar.
But I am appearing for the respondent license.
Yeah, Padi?
I am appearing.
WBS.
WBSCDCL, madam.
This is questioning the notice under section 56(2). My lord, your losses will get it. My lord, page 22. I think this is,
Type copy আছে।
my lord, legible to your losses brief. Type copy we have supplied, but
22, yes.
22
50. Now, my lord, kindly consider this, my lord. This is again order date, my lord, notice dated 3rd August. My lord, may I read it to your losses? Only thing your losses, kindly see consumer ID number 2226, last 4 digit, 2226, subject. A review of our records indicate that an amount of rupees 3,60,180 remains outstanding against the above mentioned electric service connection towards electricity charges lawfully recovered by WBSC. Despite issuance of periodical bills, reminders, the outstanding amount has not been paid. Accordingly, in exercise of the power under section 56, they have not mentioned, Electricity Act, you are hereby called upon to pay the aforesaid amount within 15 days. In the event of failure to make payment within the stipulated period, and the electricity supply to the above shall be liable to be disconnected within any further notice, all that. Kindly come to the page 23. The same consumer have two connections. I believe in the same premises. Your losses only the same date, only the consumer item number 2223. One is 2226, one is 2223. This is the amount is differs 3,58,000. Now I take your lordships to the page 24.
Page 24.
24. This is consumer ID 2226. Now, my lord, your lordships will find billing date. I will be only referring to the relevant according to me, my lord, of course. 7th April 2025. Now, your lordships will find in the previous reading, present reading. I am not disputing the reading. Then, amount due after due date. April 25, 4,16,000 odd. May 25, 37,000 odd. June 25, 37,000 odd. Total, my lord, 4,88,000 after rebate. These May and June. This is periodical bill, quarterly bill. May, June, and April I have paid. But April paid what I have consumed. What I have not, I have not. Kindly see the outstanding amount. These I have not paid. 378,740. Kindly see the bottom. As per order of WBERC, dated 16th March 2024, and subsidy from West Bengal government outstanding. This amount, your losses, this tally with that, my lord, outstanding for April 23, July 23, October to March 2025. Get your losses. Now, then notice for no accessibility of the consumer premises. Your premise was inaccessible for 2 consecutive billing. Well, that's, I think, not relevant over here. All that I'm trying to, your losses, they have changed the meter thrice. I have not pleaded all that. I have been told. The next billing, your losses will find the another, my lord, consumer, my lord, the another consumer number of the same consumer, 2223. Your losses will find that outstanding amount, your losses, 46. I have paid April, May, June. I have paid the current bill up to all that. Then your losses will find as per order dated. My point is, your lordships, kindly consider. I have put tick mark for your lordships consideration. This is bill dated 24th March 2026.
आगे 20 आगे 830
No. Kindly see. Hmm. But 2226, your losses will find here your losses no outstanding. Outstanding amount, your loss is 0. Then bottom your losses kindly, as per order of WBERC, subsidy from the West Bengal outstanding 0. Then again outstanding for what, my lord?
And this annexure P2 at page 24, this amount you have paid, 3787.
Current bill I have paid.
And this amount you have
I
not.
have not paid. They show now 0. Then again say outstanding others. What others, my lord? Because the bill says, what is this one? I've made a representation, they do not reply.
Mr. Basu, what is
Malad,
this?
may I peruse the malad?
Din.
ওটা তো বুঝতে পারবে না, আমি বুঝতে পারি না এগুলো থেকে। ট্যাবে আমি 0. Then 56(2) comes into play, according to me.
Age for April 23 was same period. Same period is being continued.
And then you'll also notice says,
Even the current bill, there is no outstanding. This is for the period for July 23 to up to 25. He did not pay funding.
In the next line, my lord. That is
I
reflected.
have
in the-
pointed out that after 0 next line, what does it mean? For what period? You have shown 0.
No, that is for the current period, my lord.
0 outstanding 0. Malad, kindly see the.
That is for the current period. Next line, my lord, that reflects, my
No,
lord, there is an outstanding, my lord.
How can it be, your lordship?
My lord, accumulation, my lord, since April 23, my lord, to 25, my lord. He has not
So
paid,
this
my lord.
0 is what?
My lord, 0, my lord, for that, my lord, I have to take instruction. But 0, what I presume, my lord, 0 is for the current bill amount, my lord.
Then kindly see the earlier
Since he
bill
has
you
paid.
mentioned
Since he
outstanding.
has paid.
Malad,
Since he has
current bill
paid.
outstanding.
But if
That
this
is for
was
the
if this was if this was the practice followed, then 0 for the current bill should also have been shown in the 7th April 2025 bill,
Exactly.
because if the practice has to be uniform. If 2 outstandings are being shown, suppose it's not an implausible thing to show 2 outstandings, but then there should be uniformity in the practice. If there are 2 outstanding shown, one in respect of the current period, another in respect of the arrears, then in that case you should have shown this in the 7th April 2025 bill also, because he has paid the current bills even in respect of that year or that period. And the bill which we are claiming relates to 2025, 2023.
Yes, my lord. So far, my lord, my instruction is, my lord, that outstanding of that, my lord, previous period, that is, my lord, the system, it has been, my lord, locked or stored in a different heading. That's why, my lord, this outstanding others is showing in the bill. That your lordship will find, my lord, the bill annexed in the writ petition, the same amount has been, my lord, carried forward in the
The
present
same
bills
amount
also.
is there, but outstanding 0 is also there. How will you explain this? There is a hashtag outstanding 0, and then there is outstanding within brackets others. And in the earlier bills, it was hashtag outstanding. Has it got something to do with the change of financial year?
Maybe, my lord.
Maybe.
Financial year doesn't have.
It may be because the billing date here, all of them
No, no,
pertain to
And Malad-
7th of April 2025. This is 24th March 2026.
Exactly.
instruction নিয়ে আসবো বটে, ঠিকই। It's a matter.
But previously they shown.
That also.
My lord, I will
within
come
the
with
financial
instruction,
year.
my lord. My lord, I will come with instruction, my lord, tomorrow. And my lord knows, my lord, since he is disputing the bills, my lord, for
I'm not disputing the bill. Sorry. I'm disputing if you do not raise continuously your amount and you cannot apply 56.
Well, this is to be, my lord, the power is with the, as per regulation
Exactly.
55, my lord, 3.5, my lord, clause. The power is
It have in 2025 it
that,
has been
Malad-
raised, Mr. Sanyal. If in 2025 it has been raised, it is for which period?
And same period what they are showing.
April 2023 to June 2023.
5. Malad, I clarify it, your loss.
If April 2023 to June 2023 has been raised in April 2025,
No, Malad, I
Then-
tell your losses. Kindly see the page 24.
page 24.
As per order dated 6th March 2024.
Yes.
So before that, there could not be any claim. Now, Malad, they have raised, presumably, in 2024, second periodical bill in the June. It comes in your lordships June 26 2 year. Now I am showing outstanding nil, then 56(2) applies.
No, but this outstanding nil which you are showing, below that there is another
Well,
outstanding
that's wrong. This
which matches with the same amount which has been
maybe
shown
your
as
lordship
24.
kindly see as per 0 where they are written as per WBRC 0. How could they claim it now? They are claiming within the clutches of 56.2 because it's continuously to be shown.
No, it is still not coming in the clutches, Mr. Sanyal, subject to what you say. In 2025, they have shown.
Shown.
In 2025, they have continuously shown. 2023 to 2025, therefore
Shown.
it is regular.
Regular.
Now in 2026 also, if they show, then where is the break? There has to be a
Break your losses 2 years lapsed.
How?
June first raise.
2 years will be the limitation if they do not show. If they go on continuously show, they can show it for 5 years also. It
No,
will
no,
not be
so
lapsed.
5 years show. But if your losses after 2 years do not show, then what will happen?
But where is that?
That's your losses I have handed up, nil.
No,
That's
but
June.
but it still mentions
So
that.
that's not, then what is that amount?
Yes, it may be a different thing as to what is
The
the
your
amount.
losses so for WBSC order 0. So your first claim WBSC was this amount. Then you say 0. Then your losses kindly come to 56 notice. A review of our records. What does it mean? Suppose you have neglected to raise it. Then you can't. It's a pure question of law, my lord.
Where is the notice?
Notice page 22. A review of our record indicates. Therefore, this notice given after review, suppose you have made a mistake in not raising your claim, then I will be benefited by 56.2. Maybe me your mistake.
The recovery will still be done, even if
Under by way of other methods, not by disconnection.
not by disconnection.
That's my point.
That is there, but I still have a doubt whether this
That's
will
what
not
they are
amount
so.
this will not amount to continuous.
That's my case, your losses. Because you have said, kindly see as per WBSC, DC, the order 0.
Explain this. If you can explain this, then this continuous thing.
Lord, I will.
When tell me.
Next week. Lord, kindly fix it for the next week, my lord.
But don't disconnect in the meantime then. This writ petition assails a notice dated August 3, 2026, issued by the station manager, Jong
that the meter room has not been completed, the pump has not been installed, and the boring is also not completed. Well, they have
Everything has
suppressed that.
been completed,
They have
Lordship.
suppressed that and filed this writ petition.
দেখি লেটারে কমিউনিকেশনটা
আমার ঠিক তেরো-
লেটারে কমিউনিকেশনটা আমার ক্লায়েন্ট পেয়েছে
বলে দিলে কি?
Lordship, let them produce the communication of the letter to
Well,
the
it has
petitioner,
been
Lordship.
instructed on 31st of March 24. It
No
has
letter has been received by the petitioner.
Why
In
not?
the meantime, everything has been completed, Lordship,
been- They have waited for 2 years.
and
Well,
they have
later-
not
Well, later
intimated us
information
anything,
be
Lordship.
served upon the station manager
Lordship.
that in respect of the completion of all these three matters, he shall do it.
The petitioner complains of inaction on the part of the respondent WBSCDCL authorities.
Petitioner, while a petitioner is the holder of domestic connection which is more than 10 years. All of a sudden they came for want of meter on our complaint. And for that, CSC demanded of rupees 1,235. That is page 14, annexure P2. We paid for the change of band meter. That is page 14.
Wanted change
annexure
of bunt meter.
Pardon?
You wanted change of bunt meter.
Yes, that is our case. And CSC demanded that amount we pay. Now, next annexure, Mala. Same day, one is bond meter, thereafter unauthorized. So two stand cannot take.
But this was, I have taken instruction, my lord. When we went for inspection, we found that due to the unauthorized access to metering mechanism, my lord, the meter got burnt. This was the amount was in respect of the burnt meter. Subsequently, the order of provisional assessment was passed. They were intimated in respect of the order of provisional assessment. The inspection.
When you went for inspection and you took charges from him about the burnt in respect of the burnt meter,
Yes.
then how did you take charges without first assessing whether it is how it has been burnt?
That is being done. If so desire, I can file the affidavit explaining this.
Limited.
Kindly. But the difficulty is that they were aware about the professional assessment, they have not participated in the
But
final order.
provisional assessment was done first, or the charges were realized first? Which
Hmm.
was done first?
It
On
is
the
of the
same day.
same date, my lord. It is of the same date.
Then-
It is of the same date.
Could this be
Keep
possible?
it on Monday, my lord. I'll take
Take
instruction.
instructions, come back, tell me, because this is something which is
Yes, I'll take instruction.
you have to take one stand. You cannot take both. If it is burnt and you have realized that you know it is for not his fault and not for his fault, the petitioner
But I did application for restoration as well as substitution is approved, my lord. Lord,
Mr. Chakraborty, there are other benches now available for hearing.
my lord
So
may
many
rest,
benches
my
are
lord may
there.
restore the matter. Substitute
Matters,
us.
benches are
Substitute
there
us.
unnecessarily.
No, no, your lord, lord. This is a matter of 2004.
Yes, so there are benches where hearing.
Very well, I'll go there, my lord. I am only praying that your lordship may restore the matter.
My lord,
Substitute.
one another application is showing in the list, my lord. That has not served upon you.
And two I have. I don't have
One
can
also there, my lord, in the list. my lord.
Yes,
What is can one?
can one. I also do. Maybe some old application. It's not with us also. My lord may restore and substitute and we'll go. Because there are other
One.
7, 8 benches have now been
Yes, that
created.
is why.
So I don't want to trouble your lordships with that.
Can one take key?
ফাইলটা দিন নাই বার করে দিই তাহলে
Affidavit of service. Supplementary affidavit.
আরেকবার রেস্ট পিস বিষয়
Can one is not here in the file. What is can one? You have to say. It's your application also. There is only affidavit of service and writ petition.
we have a copy of that.
Must know what can one is. Can one ta ki didi? ক্যান ওয়ানটা ফাইলে দিন, তারপরে লেট ক্যান লিখুন একটা অর্ডার নোট করুন।
G. There's some difficulty today, my lord. Only not
Not
today,
today.
lord. Deeply obliged, my lord.
Kindly remember this matter relates to they are enjoying the interim order. Your lordship asked me to produce the circular, my lord. Late payment surcharge, my lord. I have produced, I have brought that circular. Now, my lord, then my lord, kindly keep it on Monday, my lord.
Not this week.
My lord. Deeply obliged, lordship.
Item number 8, my lord.
Mr. Himadri Borua, my lord,
Temple matter, my lord. Last occasion there is a direction that, my lord, they
Mr.
will file an
Himadri
affidavit.
Mr. Himadri Borua appear on behalf of the petitioner, my lord. He not come to the court, my lord. That is why I pray for not today, my lord.
It is, I believe it's come up due to inadvertence. We have a date of filing, all parties have their date of filing of the opposition till tomorrow, if I'm not mistaken. However, the
Yes.
order, my lord, has not been uploaded in the
এটা
website.
Monday আসবে।
Order, however, has still not been
No,
uploaded.
no, can't be. Can't be. Don't make such submissions. It
No,
can't be.
Item number 9, Mr. Mantha is appearing with Mr. Rajiv Mantha. Due to some personal difficulty, could not be present before your lordship.
It will be adjourned because of my fault also. There was a direction to file affidavit, my lord. I have found, my lord, but I have served to my today morning, my lord. I be very honest, my lord. May I put in my affidavit, my lord?
My lord, on earlier occasion, your lordship asked me that where I want to take connection. My lord, I want to take connection, my lord. Plot number 154.
Seeking time, the private respondent is seeking time.
My lord,
Your affidavits are ready.
my lord, they are, my lord. In the meantime, my lord, I'll also serve the affidavit upon.
Affidavit in opposition. Affidavit in opposition filed on behalf of WBSCDCL.
I beg to appear on behalf of the respondent number 4.
Short passover.
Passover.
11, my lord, I am for the petitioner, my lord.
Keep down appealing for the distribution company, my lord. He is suffering favor. Can you take it? Suffering favor, my lord, has not come to court.
Not this week.
Not this week, my lord.
Not this week.
My
Next.
lord, 24 is my difficulty, my lord. 25th,
25 তারিখ করে দিন
25.
25 20
Get.
Lordship, I appear for the petitioner. In this matter, Lordship, the Section 14 order has been passed on 2nd June 2026. However, Lordship, the coordinate bench kept the matter pending in light of the marital dispute between the private respondents, Your Lordship. The purpose of the writ has been solved as Section 14 order has been passed, Your Lordship. The writ has become infructuous.
And I have no quarrel with that. If the writ has become infructuous, I am the husband. There was a marital discord. The matter traveled to 13B stage. 13B is over. Now, the bank has apparently, in pursuance of the Section 14 order, or even prior thereto, has taken possession of the property in question.
There is a Section 14 order, Your Lordship.
This writ petition
Lordship, I appear for the respondent bank, Lordship, led by Mr. HON'BLE Pramanic.
we are appearing for the petitioner.
Yes.
Why was this mentioned?
Lordship, this matter was mentioned at my instance, my lord. At our instance, I am appearing for the respondent bank. My lord, the petitioner initially had filed his writ petition challenging the SARFAESI action. My lord, thereafter they went to the division bench. The division bench thereafter had affirmed the order, and my lord, it was remanded back. The writ petition is now pending. Pursuant to direction passed by this honorable court, my lord, we have already taken physical possession, and my lord, we are yet to sell the property, my lord. I do not think the writ petitioner will again appear in this matter because they have lost their force. My lord, I have given notice. If your lordship
Not as
wants, I
per-
can.
None appears for the writ petitioner. No
The
accommodation is
State also, the police also filed a report, my lord. The possession has been given, my lord,
Very
as
good.
per instruction. my lord.
No accommodation has been made for. Full stop. The learned advocate, Mr. Bhattacharya, learned advocate appearing, Bandopadhyay, learned advocate appearing for the state, files a report. Full stop. The same is taken on record. Mr. Pramanik, learned advocate appearing for the bank, submits that the writ petition has become infructuous inasmuch as the earlier order passed by this court, by a coordinate bench of this court, was carried in appeal before the Honorable Division Bench, and the appeal has been dismissed, holding that the writ petition is not maintainable. Full stop. Since the petitioner is not represented, list
I am
this
for the
matter.
petitioner, Your Lordship.
Yes.
I am for the petitioner, Your Lordship.
What do you want to say?
It was mentioned, Your Lordship. I have no objection if it. I have
I'm
no.
dismissing this then.
Yes, yes, Your Lordship.
Full stop. You have a copy of the order, Mr. Pramanik.
Lordship, my junior is there. She will hand over a copy of the division bench order.
None of you as petitioner কেটে দিন তাহলে উনি তো আছেন হ্যাঁ লিখে দিন যে this writ petition একদম স্টার্টিং থেকে একটু অন্যভাবে লিখতে হবে ওনাদের সাবমিশনটা থাকবে শুধু স্টার্টিং এ একটু চেঞ্জ করে দিন this writ petition has been filed assailing the action of the bank under the relevant provisions of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act. ঠিক আছে তারপরে ওই মিস্টার প্রমাণিকের সাবমিশনটা তারপরে স্টেটের সাবমিশনটা ফুল স্টপ প্যারাগ্রাফ যেখানে মিস্টার প্রমাণিকের সাবমিশন রেকর্ড করেছেন সেখানে লিখে দিন a copy of the order dated March 7, 2026 has been handed up to court. But here it has been said writ petition will be decided on its own merits.
Yes, my lord. Kindly, my lord, since this order was for appealed against, so my lord, the learned division bench did not interfere with the order of this single bench.
What was the order of the honorable single bench?
The direction was given for taking physical possession. Justice Kapoor's order, my lord, if your lordship takes.
আরো লিখুন during has handed up to court. Full stop. The said order reveals that the interim order passed on this writ petition directing the state authorities to ensure implementation of the order dated August 2, 2021 prior to the returnable date, i.e. July 13, 2026. Full stop. Paragraph. The said order was not interfered with by the Honorable Division Bench when MAT M1063 of 2026 was dismissed by the order dated July 3, 2026. Mr. Bandopadhyay, the report filed by Mr. Bandopadhyay indicates that the police authorities have implemented the order dated August 2, 2021 and handed over possession of the secured asset to the bank. Full stop. Such fact is confirmed by Mr. Pramanik, learned advocate appearing for the bank. Full stop. You have received possession, Mr. Pramanik? Stop. In such view of the matter, comma, the writ petitioners, the writ petition has largely lost life. Full stop. Paragraph. In any event, comma, an action taken by the bank under the relevant provisions of the 2002 Act is assailable, is amenable to the jurisdiction of the statutory forum, i.e. the Debts Recovery Tribunal under Section 17 of the 2002 Act. Full stop. In such view of the matter, comma, WPA 13265 of 2026 is not entertained. Full stop. WPA 132 of 13265 of 2026 stands dismissed. No costs.
I'm grateful, my lord. My lord has recorded the discharge order is 3rd July 2026.
Yes.
Yes, that is correct. I'm grateful.
Come back in 5 minutes.
Jim, I'm appearing for the petitioner. The last occasion, there was a direction upon the WB SCDCL to file a report. With respect to Lordship, the grievances, Lordship, the certain unauthorized occupants were using the meter and electricity supply at my premises. It's a factory premises in Haldia. However, my business has been stalled completely because of the lack of electricity at the premises, and the private respondents, they are the unauthorized persons at the premises. They were using another meter from the same supply. Lordship, in this petition was filed. Recently, what has happened, Lordship? Certain persons claiming to be the station manager of WBSCDCL, they have they have forcefully entered the premises day before yesterday, Lordship, and they have uninstalled the meter being used by the private respondents. And Lordship, the original meter which belongs to the petitioner is still there. I'm only praying that the supply may be resumed, Lordship. There is no supply at the meter. However, the report, I believe my learned friend has not filed, therefore it has not been supplied to us also.
Well, there is a direction to file FAQ. There is no direction to sub the copy. It's a report to be filed.
A copy may be supplied, Lordship.
See the dispute between the petitioner and respondent number 4 and yes. The dispute between the petitioner and the
no disputes, Lordship. They are unauthorized.
Between the petitioner and the respondent 4 and 5. Petitioner, Lordship, kindly see the name of the petitioner. Sanchem Paints Private Limited. Original connection is in the name of Sanchem Plastic Private Limited. We do not know when it was changed from Sanchem Plastic to Sanchem. There is no whisper in the petition itself. They have admittedly entered into an agreement with the private respondent number 4. This particular meter was unused and the huge amount of the dues was there. And on the basis of an authorized signatories application, we have disconnected it. We have disclosed all documents in my report. I'm applying
Lordship, these are all forged documents, Lordship. Lordship will kindly take the representation that was initially issued to the
page 20.
In my petition, it is there, Lordship.
Page 9 of my report.
Page 9.
This is, my lord, we have received from, my lord, the Sanchem Plastic Private Limited, who happened to be, my lord, our consumer.
When did you disconnect?
My lord, yes. This, lordship, can you turn to next page, my lord? The person who has been, my lord, who has claimed to be the authorized, my lord, it is his, my lord, the voter's card. We have also collected. Immediately thereafter, my lord, it was disconnected.
No board resolution, nothing has been produced.
Sometime, my lord, 2016. It was disconnected in the year 2016.
Lordship will...
Kanti Goldar was one of the directors.
Yes. Sanchem Plastic.
Lordship, I am told these are forged documents for which the complaints have been made. Lordship, what is the present scenario? My supplementary affidavit is being affirmed, Lordship. Presently, there is one meter, that is my meter, which is lying without any supply. That supply, Lordship will kindly consider my representation at page 28. In reply to my representation, what my specific prayer was to resume the connection at my meter. The reply then, Lordship, my representation starts at page 28.
Yes.
Lordship, I had requested for an inquiry to be held why some other person who is not authorized, not even my tenant, and I am not legally, these unauthorized persons have applied before the WBSCDCL. I do not know how they had got
the same name. The representation at page 28.
Yes, my lord.
Carries the same name, Manish Goldar.
Yes, but the signature, Lordship will now kindly come to the reply that has been received at page 31. This was issued by the station manager. Lordship, initially it is stated that there are bills outstanding. However, it has been recorded that on 2nd of February 2016, all bills cleared. There was nothing outstanding. Thereafter, Lordship has found at the first bullet point.
Yes.
Yes, Lordship, towards the fourth line of the third line of the first bullet point, subsequently the entire outstanding.
If there is, sorry, Chattopadhyay, if there is no more outstanding in respect of the same meter, can the supply not be restored in the?
Now, Lordship will kindly also appreciate the second point that has been taken in this letter, Lordship. Following which an application for permanent disconnection. Lordship, there has been no disconnection. Lordship has seen in my representation that there was no request for disconnection.
No,
At the
they have
last,
acted on this because if
I
somebody,
understand, Lordship may,
somebody forges the signature, then in that
that
case,
is a I understand. Lordship will now kindly consider the last point. In view of the above recorded facts, the allegation that the connection was disconnected without authorization is not substantiated. Further, the request for restoration of the earlier connection is not tenable as one electric connection already exists at the prior premises. Now, presently, Lordship, I shall file my supplementary affidavit. Day before yesterday, Lordship, the earlier meter which was in the name of the one of the private respondents, Lordship, that has been removed by the station manager. Presently, only my meter is there.
if only the petitioner's meter is there and the petitioner wants the supply to be restored, what is the problem?
Now, my lord, if you lordship kindly come to page 11, 11 of my lord report. Page 11. My lord, lordship kindly see, my lord, the name of the consumer. Sanchem Plastic. Now, my lord, kindly see, my lord, now, my lordship kindly come to page 3 of my report. Page 2, my last line. It was requested to disconnect the industrial electric service connection in respect of consumer ID 2240183111. Now, my lord, next page, my lord. Based on the application, electric service connection was disconnected on 29th February 2016. My lord, after 10 years, my lord, this representation has been made.
Lordship, there has been various requests made for connection. This was the only factor.
May I intervene?
Just a moment. If all of this is because you also would like to have business, you would also like to have business. It's if a consumer may, let us suppose that Sanchem Plastic is not replying, a new consumer is applying for electricity connection. Then also in that case, if you find that the person is in occupation of the premises, wants electricity supply, there is no outstanding.
Lord, that is the issue.
Lordship, the other issue, Lordship.
I filed the report, my lord, since my learned friend, my lord, has taken out my new fact, my lord, whether it has been removed, my lord, what happened.
No, my learned friend will be instructed.
Then, my lord, let me come back, my lord, next week, my lord, with instruction.
No, Lordship will
Lord,
kindly.
that is the issue because I am the owner of the property.
Same company.
I am the owner of the property. The petitioner is the lessee. My lord, the issue is that they are not in possession.
Yeah.
They had filed a separate suit, a separate writ petition, which was disposed of on 10th August, my lord. Actually, what has happened, they had subletted, admittedly, they have given to private respondent number 4 to 5 in 2015. They admit that in the writ petition.
It was a license for 11
Maybe,
years.
leave and license.
That has expired.
Saying what?
Saying, because, my lord, what has happened, on 25th March 26, I issue them a letter, show cause, that you have, without permission, sublet my property to the private respondent. Now, they give a reply. On 20th April 2026, we issue another notice considering their reply that you have violated the provisions of the lease deed. So, we are entitled to take steps. Now, those two letters they challenge before this honorable court by filing of another writ petition. So, the honorable judge, coordinate bench, my lord, directed us to consider their representation and decide on merits. Because my lord, as per the lease deed, I am entitled to terminate the lease because there is a violation. Now, my lord, and they filed this writ petition, my lord, on 15 June.
Who are you representing?
My lord, I am representing Haldia Development Authority. They are the lessor. After these notices, my lord, they filed this writ petition in June 26.
Sir, this Lordship, what has happened? The electricity supply has been stopped. Lordship has seen the only ground that some other person is using, only one connection will be provided at the premises. I am not being able to carry out my business because of some unauthorized person who happened to enjoy the electricity supply provided by the WPSC.
There is no business, your lordship.
There
Kindly
is no
appreciate 10 years, after 10 years. It was
Lordship,
disconnected in
Lordship,
2016.
that issue, Lordship, if I am today.
May I hand over the order once which was passed, madam?
There is a timeline given where I am directed to decide on their representation.
Lordship has no connection with this writ petition.
My lord, it fell from your lordship that who is in occupation. My lord, that is what I have been directed.
I am in occupation, Lordship, but my learned friend perhaps is not properly instructed.
What was your show cause?
My lord, my show cause was that without any permission from me, you have subletted and that is admitted. They say leave license.
It's 11 months.
They say leave license, my lord.
Expired also long back.
My lord,
After that, these occupants enjoying
my lord,
electricity.
once we come to know that, we issue them a letter that you have inducted third party in my property without permission. So kindly show cause. Then they give a reply and they admit that they have inducted. My lord, thereafter, at the show cause stage, they challenge those show cause notices by filing this writ petition.
No, but show cause only will be why, how you have inducted, or show cause will also be with some kind of consequence that if you do not show cause, you will be evicted or something of
Nothing, Lordship, nothing of the like was there.
The coordinate bench directs you not to take coercive action.
Yes, ma'am.
What will be the action which will be
So
coercive?
coercive action, my lord.
Evicting them.
Coercive action, my lord. Your lordship will find there is a direction on me to decide on their representation.
Inspection, Lordship, there's a direction.
Is also not to take coercive action. Why I am asking this question is, if you have been restrained from evicting them, which may be a coercive action, that means they are in possession.
Yes, my lord, I'm
That
grateful.
is what I want to drive at.
I'm grateful.
If this coercive action was
Coercive action means coercive.
was their eviction, then in that case,
Coercive action would mean, my lord.
possession.
My lord, coercive action would mean, because my lord, the lease deed, my lord, those documents are not in this writ petition.
Very well.
The lease deed,
Since
my
you have
lord.
taken this point, and it is for them to satisfy the
My lord, the
licensee that they are in possession. If they are found to be in possession,
my lord, that is what the inspection has also been called for. Your lordship will kindly see.
Kindly, it is there, admission. So kindly come to page 9 and paragraph 11 of the writ petition. It is,
Lordship,
it is
may I be
affidavit.
permitted to
They are
file a
not in
supplementary
possession.
affidavit to bring on records the present
file a
scenario?
supplementary, take exception.
Lordship,
to the
kindly come to
report.
paragraph 11.
Yes,
Kindly
yes,
come to
ma'am.
paragraph 11.
Lordship, only Lordship will temporarily may my connection be restored, Lordship.
After the report comes,
It is the continuation of the writ petition. I mean, in paragraph 11, my lord, they have been.
Lordship, may I be
evicted.
heard out tomorrow, Lordship? I am without electricity at the premises, even the staff.
They say they forcibly evicted, my lord.
Lordship,
that you have been since 2016. Why this extreme urgency now, Likhanin? Next Thursday. Next.
Lordship is,
Lordship, Dr. Madhusudan Shah, I represent WBSCDC.
Lordship,
Dr. Madhusudan Shah, I represent WBSCDC, Lordship.
here is a exception on behalf of the petition. Lordship, in exceptional petition, kindly page 2, para 4. That before the installation of the said distribution transformer, I had already submitted the aforesaid written objection dated 11 June 2026. Thereafter,
You see paragraph 7 and 8 of the
7 and 8
7 and 8 of the report.
report. Kindly page 5, there is my reply. Para 9, the paragraph 7 of the affidavit filed by the respondent number 6 state that nearest building from the transformer is at distance of 4.2 feet and the 14.2 feet. Then that said building does not belongs to me, but the said statement does not answer my actual grievance, as I am not claiming that the legality of the installation depend only upon the distance of the transformer from a building belonging to me. Rather, my main grievance is that transformer has been installed at the dispute location.
Disputed location. What do you mean by disputed
They
location?
say it is a government land, but kindly page page 11.
Page 11 of your exception.
Exception. There is no Khotian number 1, which shows that it is a government land.
Whose land? It is your land.
It is own my land, and respondent number 6 says that a Pradhan of the concerned panchayat see the land, it is a government land. Pradhan is not the authority or empowered to decide a land is government or not. BLRO or as per section.
Where is Dr. Shahara?
He is engaged in code number 24.
Please take his exception. Yes. Please come to page 11. According to your report, you say it is a government land.
Lordship.
Where the transformer has been installed. Now, page 11 does not show that it is a government land. This is the record of rights of the relevant land where the transformer has been installed.
So far my instruction is concerned, it is not on the government land, and the photograph there. Can
You say it is on, you have installed it on his land. That is his contention.
His contention is not in his land. He said adjoining. In the read
His
petition.
contention is it is his land. Where have you said that?
In the read petition, he never stated.
Where have you said that it is on your land?
Read petition.
Rupshana Begum 7214.
Not whether the transformer has been installed.
Yes, page 5, paragraph 6 of the writ petition. Page 5, paragraph 6.
My instruction, it is not in his land, it is in the government
That
land.
is his allegation. It is not in government land. He has shown the
I
recorded
also
rights.
also
But
conduct a
this is the
survey.
photographs.
Photographs will not show. Recorded
Lordship-
rights will show whose name it is recorded.
in
Back
the-
page 11.
In this plot, because the inspection has been made with the
Dr. Sahara, there is a record of right on record, page 11, which shows it is not government land.
In the report, kindly page 2, para 5, transformer has
kindly
been
see my
installed.
letter. Kindly see my letter, page 9 of my affidavit.
Yes.
But that has to be decided, Lordship.
Who decided? A station manager.
Your allegation in paragraph 5 at page 2 of the report is that transformer has been installed on the government land as identified by the local authority. That is here. His land, he has shown page 11 of the report in the form of, exception to the report that is filed by you, has been filed by you.
There is Lokotian number 1.
Lokotian number, the fourth entry, 7214.
Lordship.
Vastu, writ petitioner's name.
I am
And
not
the
disputing that.
other
Ayatullah Mullah.
are also not government. All of them are private people.
It is riot
How
property.
do you say that it was installed on government land?
But in the road, near the road, Lordship. Then I
Near
have
the
to
road,
take
no, it is
instruction on that.
Panchayat road.
That was the report. That was the report. That was the
Instruction,
case.
you declare.
Lordship, kindly see the page 9 of my affidavit.
I've seen page 9. That does not answer the question. The question is whether it is owned on government, it is on government land or it is on the private property of the petitioner. That was the.
May I submit one thing? May I subject to Lordship kind approval? Let the matter be relegated to the concerned DM. Let there be inspection on that issue, whether it is his land or it is placed on the government land. So on that basis, then
DM is the actual authority, but the
their
station
land,
manager
then the necessary
decided
steps will be taken.
it is
DM should decide that.
DM should decide it.
Let it be decided by the DM.
And a joint inspection in presence of the police personnel.
Yes.
I am for the petitioner, followed on the prayer made by me before Lordship to take instruction from my client. An instruction has come. He is not agreed to file any exception to the report filed by the authority concerned. So, your Lordships.
So it is in a green zone.
It's in a green zone.
So there is no scope of interference.
Lots.
He can
Dispose of the.
Yes. This
Lord, I'm just submitting on behalf of item number 8. I had submitted before your lordship today with regard to the uploading of the order. My lord, I could not find it here. I had submitted that the order has not been uploaded. My lord, I believe, my lord, it's still not been uploaded, unfortunately. There has been some inadvertence. I'm just.
BM के डाकुन पाशे एस लेखा আছে কেন আপলোড হয়নি?
I could not find it here. I apologize to your lordship. I am still apologizing to your lordship. It somehow has not been uploaded, your lordship. Probably it is my inadvertence, my mistake, but I am unable to find it. That's all, my lord.
দেখুন BM কে ডাকুন দেখা করতে বলবেন। The order is signed in the file. Why should it not be uploaded?
It's probably an inadvertence, my lord, but just I wanted to bring to the notice of your lordship.
Thank you. We filed that. সাত তারিখে তাহলে আপলোড না করে এস লিখে আপনার কাছে পাঠিয়ে দিল। Yes.
Service in 3 ways. Even the
Pass
service has not been delivered. And there also has been delivered, and my learned friend is appearing on behalf of the private respondent. In 3 modes I have served.
We had to take a lot of pain to ensure your appearance.
Lordship, I have only been informed by my clients
recently. At least 3-4 orders have been passed. Police, machinery, President of India, everybody had to get elected. I did not know because my client only came to the last week, Your Lordship.
Landlord tenant has been interrupted from getting electricity.
How do you object to his electricity supply? Your Lordship, I cannot object to them receiving electricity. That I admit. Now, the only thing I could say with Your Lordship is that they have applied for a new meter box. Now, my case is that their husband was the original tenant. They already had an electricity line. Now, since they had not paid the dues for continuous dues, the line was disconnected.
Since the meter room has not been accessed, I have pleaded. And my lord, that is the problem, my lord. I have applied for new. I have to take the trouble. My lord, so the
Let them clear the
it's
dues
my
and-
in my cost, my lord. My lord, I will not claim any equity in the suit.
Yes.
I will not claim any equity. Cannot be. It's only my fundamental right.
Can be restored, Your Lordship. I'm only saying that the
Then, my lord, again this problem will be there.
electricity line was already there, Your Lordship. That you sort out, he's entitled to fresh electricity supply in his name. No objection to that. If you have anything against him, you can sort it out in your civil suit. Yes, that is already pending. Then, Lordship, I'm only stating that new meter may not be installed. Why not? No. Then, Your Lordship, लिखे नहीं. Your Lordship, one small indulgence. Since new meter box, Your Lordship.
I am for WBC.
My lord, I am appearing for the petitioner, my lord. On the other day, that is on 12th of August, your lordship heard the matter and kindly see para 5 of your lordship's order. I was directed to take instruction from the client whether any quotation has been sent to the client by speed post or not. My lord, I have taken the instruction yesterday. No such quotation has been sent to my client, my lord. And therefore, my present grievance is, my lord, they are sending the earlier bill wrongly calculated with the present bill, my lord. That is my main grievance. And my lord, on the other day, I prayed before your lordship, page 22.
My
of the
inspection is that he has
petition.
already received it. We sent it through speed post. The item has been delivered. He did not accept the quotation by hand. That's why we were compelled to send by speed post. He has received it. Quotation, my lord, your lordship kindly
He
remember.
has not received it.
Then, my lord, I have to ascertain and the case
My
is, my
lord,
lord.
my humble submission before your lordship, my lord, kindly dispose the matter, directing them to send the bill by speed post again, my lord. And my lord, they should be stopped to send the bill, earlier bill, wrongly calculated with the present bill. That is my main grievance, my lord.
But let me now understand then. If you want disposal, please.
Yes, my lord, I am taking disposal, my lord.
Last occasion it was submitted that by speed post it was sent on 29 July and an amount of rupees 42,950 was due and payable from you.
Yes.
Yes, my lord. My submission, that quotation has not been received by my client as yet. My lord, yesterday I took the instruction, my lord. And my lord, another
29 July, how it
No,
My
my lord.
question is, my lord, the item has been delivered. My lord, I can produce the, my lord, track report right now.
I will produce the track report. I'm keeping it on Monday. लिखे नहीं.
My lord, my submission is before your lordship
Acharya,
that
please appear personally on that day because this way it is becoming very difficult. लिखे नहीं. Mr. Bhattacharya submits that no quotation has reached the petitioner as yet, although, on August 12, 2026, when the matter had been taken up last, it was submitted that such quotation has been sent by speed post on July 29, 2026. Full stop, paragraph. Mr. Bandopadhyay, on the other hand, submits that he has instructions that the postal article sent by speed post has been delivered to the petitioner. Full stop. He seeks time to produce the postal track report. List this matter on Monday.
My lord, instead of Monday,
Please be present on Monday.
my lord, instead of Monday, my lord, can it be, my lord, subject to Tuesday?
my lord, Tuesday I have some problem, my lord. Kindly take the Monday, on Monday, my lord. I have some problem, my lord, regarding my health, my lord. Otherwise, I could not submit before your lord.
Monday.
Very good. Great.
My lord, 19, my lord, I beg to appear. My lord, pursuant to leave granted by my lord, I have filed supplementary affidavits, my lord. My lord, 18th, my lord, I have received a notice from 18th evening. I received a notice from the East Kolkata Wildland Management Authority indicating me to give certain information, my lord. My lord, if your lordship kindly takes up the page annexure P8 that I have, a copy I have handed over to my learned friend, which says.
There are two supplementary
Yes,
affidavits.
my lord.
Which one?
The thinner one.
Yes.
Page 5, my lord.
Page 5?
Yes, my lord. This is a communication we have received on 18th. Today we were on 20th. They have asked for certain information that I am required to provide them. The RS plot number and Mouja name, my lord, and that number. Now, lordship, kindly adjourn the matter and keep it in September, my lord. I will make the same to provide the information they have sought for within today or
So
tomorrow.
what they
my
have said,
Yes.
Sector 4 Salt Lake falls within East Kolkata wetland.
No, my lord. Well, on other day, a document was handed over by my learned friend, wherefrom it appeared that the ward number 35, part of the ward number 35 comes within that zone, my lord. And now they have stated sector 4. Sector 4, I have taken instruction, there are more other wards, number of wards. 35 is one of the wards. So part of the 35 come within that zone. They have asked me to provide certain information. I will provide that to the authority by today or tomorrow, my lord. Keep it in the month of September so that I can get and come back.
September, you will not be able to get information.
Kindly see the letter. Probably Lordship has gone through the letter.
They will take 1 month
Wait,
again. And
I said that I give the suggestion, let it be relegated before the EKWA with all details, let them submit, let the EKWA decide whether it belongs to the wetland or not. Otherwise, it will continue.
Kindly
Subject to
give me
Lordship
a
kind
chance.
approval.
Kindly give a chance.
supplementary affidavits filed in court today are taken on record. Full stop. Copy thereof.
My lord, I am for the petition.
Repeating on behalf of the respondent number 7, private respondent.
My lord, this is a writ petition for new connection.
Supplementary you wanted to file.
Supplementary, my lord, I have filed certain documents because previously there were 2 rounds of litigation. One writ petition was filed, my lord, against some private respondents who are not made a party in this present writ petition, because on behalf of the private respondent, my learned senior friend appeared in that writ petition and said they are not the necessary party in respect of the instant writ petition. So that, my lord, I have found one document submitted from the, my lord, report submitted by the WBACDCL, my lord, in that prior writ petition. From there, my lord, I got acquainted with the fact that the present private respondent is the, my lord, owner and occupier in respect of the property, my lord. Though, my lord, there was no formal communication regarding objection of my new electricity connection, my lord, still, my lord, I have made her a party as a proper party in this instant writ petition. So, my lord, if they will, my lord, certainly make any objection, they can, my lord, do that. But on last occasion, my learned senior friend submitted that on behalf of the private respondent, all probably there was no objection in respect of my new connection.
Yes. My lord, your lordship, kindly see the report of the WBSCDCL, which page number, my lord,
My lord,
83 of
supplementary affidavit, my lord, I have served, but I have not submitted.
page number 83 of supplementary affidavit. Annexure S2.
Page 83.
83. Annexure S2. My lord, your lordship, kindly see the report of the distribution company. Your lordship, as per the honorable court's order, inspection was held. And my lord, inspection was held on 29th October 2025. But my lord, no mention in the premises number. Your lordship, kindly come to the item number 1, service connection in a single room where she resides in rent as per applicant's verbal statement. There is no document. Secondly, my lord, Gita Sinha could not provide any land document or rent agreement document during the joint inspection. Your lordship, kindly come to Item number 3. One deemed disconnected connection in the name of Srimati Uma Kormokar, having meter number L0768645, has been found at the said premises, that is, I do not know which is the said premises. Outstanding dues against which stands as rupees such and such. Your Lordship, kindly come to page 33 of the writ petition. Have your Lordship found? Yes, my lord. Your Lordship, kindly see meter number L0768645, which is mentioned in their report. And my lord, your Lordship, kindly see the name of the connection.
What did you want to show?
My lord, Uma Kormokar.
Yes.
My lord, he is the he has connection. He had connection. Now he is deceased. My lord, Uma connection is, dear Lordship, kindly come to page 32. Uma Kormokar, just previous page. Uma Kormokar, death certificate, my lord. Son of Bira Kormokar, son of. But my lord, inspection report says that Srimati Uma Kormokar. And not only that, that number was under Uma Kormokar. Now, your Lordship was pleased to see that they have stated the LPSC connection charge and meter charge was due. But my lord, now it is the, your Lordship, kindly see once again the premises number, Uma Kormokar, page 33, premises number 20/18 Ghoshpara Road.
Yes.
My lord, seen that? Now he has claimed for new connection 20/2 Ghoshpara Road. 20/2, I have no objection. But my lord, they have stated due, he wants that means he conspiracy demanded this amount from Gita Kormokar. But my lord, he wants to give connection this number. But my lord, this number is of my husband, elder brother of husband, my lord. So, my lord, if electricity board, electric distribution company wants to give connection 20/2, I have no objection. But regarding this, the report of the SADCL company, I have made objection.
That was, my lord, previously submitted.
My lord, I make it clear on the last occasion, we made inspection, we have no objection to give connection. Because
which is the premises where you want supply?
20/2, my lord. 20/2 Ghoshpara Lane.
What is your
the
problem?
number
They will
is,
effect it 20.
she is residing in a my lord, small room, and our officers went there, made inspection, they found it is feasible and possible to install the meter. Now, my lord, we do not know whether it is 20. Number we do not know, but
20/2 only.
physical presence is there.
No, not.
Then why have you annexed these documents of 20/18 or something?
Pardon, my lord.
Why have you annexed these documents showing a different address?
My lord, my Aadhaar card is showing it is 20/2.
No, the other document that you have annexed, this electricity bill and all.
No, my lord, that was the affidavit in opposition submitted by them, the private respondent, in my prior writ petition, because I have made someone party who said that they are not, my lord, the resident of 20/2. In support of their contention, my lord, they are not resident of 20/2. They have submitted those documents, my lord, which have.
What was the occasion for you to annex that affidavit in this writ petition?
Because my lord is all interconnected. Because my lord, kindly come to the report submitted by the WBCDCL in my previous writ petition.
My lord, this number is there.
He made a party.
Page?
Because my lord,
Page,
there is no connection
my lord,
with that.
may I submit, my lord?
Premises.
May I submit? My lord, page number 84. Kindly come once. My lord, in my supplementary affidavit.
Now your supplementary affidavit is the writ petition now.
It is, my lord, the previous writ petition and the.
But your main case is in the supplementary. Yes.
Because my lord, it was not required though. The kindly come to the report submit. May I submit, my lord, if my learned friend permits me?
Page 84.
My lord, in page 84, my lord, kindly come to the lower portion, my lord, of the report. My lord, handwritten notes. On handwritten notes, my lord.
Yes.
As per joint inspection on 17th of November 2025, the applicant Gita Sinha wants HSC where so and so found so and so deemed Uma Kormakar so and so. My lord, kindly come to point number 2. The applicant resides in a single room. My lord, it is given. My lord, now the signature portion on the right side. My lord, it is coming Lokhi Kormakar on behalf of representative of the respondents. And my lord, kindly may I complete it?
Yes.
And my lord, kindly come to the next page. The Aadhaar card was also annexed of Lokhi Kormakar, my lord, where it is shown that, my lord, the address is 20/2. And my lord, the mother of Vishwanath Kormakar, Chandani Kormakar and Akash Kormakar, who had made party in my previous writ petition. That's why, my lord, from those documents, my lord, submitted on behalf of the WBSCDCL with their report in my previous writ petition, I got acquainted with the fact that Lokhi Kormakar is presently residing in, my lord, in 20/2 as an occupier. I do not know the status of the Lokhi Kormakar. Now, my lord, verbally or written, they have no objection, as they have already said. And I have made them the party, my lord, if they are trying to raise any objection, so that, my lord, they can raise the objection before this honorable court. Nothing less, my lord. Nothing more, nothing less.
You want it at which place? Premises number 80/2.
20/2 my lord, Ghoshpara Road.
And Lokhi Kormakar is not a resident of 20/2.
Your lordship, kindly see that.
Is a resident of.
Not a resident of 20/2. That is her case.
Yes.
My lord, her Aadhaar card is showing that.
This is her Aadhaar card. It's 20/5.
Now, my lord, the Aadhaar card submit, my lord, from.
देखिए दिनों
Now, my lord.
they will decide through which meter.
That is under Uma Kormakar. And he's
That will be decided by them. I will not go into that. I will say he is entitled to Sashi.
difficulty because
Mr. Sanal had mentioned in the morning, his junior's mother has expired, so he had to leave.
My client is living without electricity. That is the problem. Immediate convenient.
Tuesday if it Tuesday করলে করো সেকেন্ড হাফে তোমার হবে না ইন্টারটা তোমার ফার্স্ট হাফে হয়ে যাবে সেকেন্ড হাফে রাখো যদি খুব অসুবিধা হয়
Fixed আছে.
Fixed আছে. Thursday was possible, but
Mr. Sharnal has said Thursday will be a bit of difficulty 25 ইলেকট্রিসিটিটা
সে তো নেই, আরো টাইম।
সোমবার হবে না তোমার না
Monday,
This Monday?
no, 31st.
Monday আচ্ছা কিছু fixed আছে না? We can have it on Friday.
ফ্রাইডে করো ফ্রাইডে করো
31st fixed আছে।
এই ফ্রাইডে
This Friday. At this Friday, I have a matter fixed at 2:30.
31st, we have fixed matters. 31st, we have matters fixed.
হ্যাঁ 31st এই
1st
ফ্রাইডে
September, we can have.
No, Friday, first half it is possible. First half it is at 12.
If I have fixed matters, both halves, then the board will be stalled. We can have it on the next day, 1st of September.
1st of September.
1st
Yes,
September.
yes, I am completely free.
1st September, 2 p.m. for it.
At 2 p.m.
2 p.m. is the best.
2 p.m. is.
First half, we'll have some motions and then we can.
Yes, একদম
When we say under the control, on that day we are going to control.
ফার্স্ট সেপ্টেম্বর ঠিক আছে ওইটা নিয়ে নিস ওইটা
Item number 10, my lord. Item number 10, I am appearing on behalf of the respondent.
তো নেই, ছেড়ে দিন, এগিয়ে যান। কেউ নেই তো, petitioner নেই।
Petitioner.
Petitioner is not there. He's not there, I'm making it not today.
My lord, not this week then, my lord, kindly. Not this week, my lord. Monday. Not Monday. Grateful, my lord.
I am for the PTSC, my lord.
I am for the private respondent.
On the allocation, my lord, I have submitted the report.
Who is appearing for private respondent? You are appearing?
No, my lord.
আরে কি না প্রাইভেট রেসপন্ডেন্ট হয়েছে
Private respondent.
হ্যাঁ
You are appearing for private respondent?
Yes, my lord. Sorry, sir.
my lord, this is the case, my lord.
He wants shifting.
My lord,
You said that shifting is not possible.
because, my lord, the petitioners and the respondents are residing in two adjacent premises. My lord, there is a partition suit pending and there is order of status quo. Now, my lord, both of them are deriving connection from a common meter room. Both the meters are, my lord, live. But the respondent has locked the common meter box position, my lord, due to which the petitioner is not being able to draw the internal line. And, my lord, what we have inspected, my lord, it is a absolutely undemarcated land, marshy land. Photographs are there, my lord, full of water logging and bamboo fences. So, my lord, it will not be feasible for us, my lord, to make two separate service connections for two buildings in
The meter room is in common place or in some
common place. Common place.
Then why are you locking
The
it?
photograph is there.
Key already, my lord, is there, my lord.
Where? Key is with where? With whom?
Petitioner. Before the petitioner.
You have a key?
No, my lord.
No, my lord. Yes, my instruction is that, my lord.
No, my lord. So let that be.
Very well.
put on
Then they
record.
will go. Then they will go. I will direct the police to break open the padlock if you don't give the key.
Yes, my lord, I will keep.
And, my lord, one thing, my lord, we can do.
That
my
is
lord,
so, why should I come to the high?
petitioner is inclined to give the connection, my lord. Our men can be there for a particular time. Who will, my lord, switch off the connection till the connection is linked.
My lord, police protection order must be there because.
না ওরা তো অ্যাডমিট করছে যে তোমাকে চাবি দিয়ে দিয়েছে
No, they have not. তাহলে আর আমি হাইকোর্ট এলাম
We are for the petitioners in item 23, right? On the point involved in this,
We have seen the judgment,
whether,
yes.
whether acquittal in the criminal case entails.
There are Supreme Court judgments also, galore, lots of judgments on this.
Entails the petitioner to have refund of the final assessment.
Sir, there are a lot of judgments. This is well settled now.
Well, I relied upon a coordinating bench judgment, my lord. Kindly consider and decide it.
But these coordinate bench judgment, which I have got the occasion to appear, and it has been stayed by the division bench already. And judgment where it has been considered so far one.
There is a recent Supreme
Yes,
Court
yes,
judgment.
I'm relying on that.
Recent Supreme
Yes,
Court
recent
2 pages judgment.
2 pages. I am here with that. I know that what a lordship. That's a 2-point lordship. Subject to lordship and approval. 1 point is involved. First of all, this matter has been stayed. Secondly, one Topenchen judgment has been relied by in this matter, where the division bench has already set aside that order. And so far, 154 is concerned, your lordship. I have got that Supreme Court judgment. I know that it will fall from your lordship and carrying that judgment, but this is the judgment. আবার date কে well settled situation আবার date fix করার কি আছে? আপনি তো আমাকে দিন।
You have seen this judgment of the Honorable Supreme
No,
Court?
Yes. Allow me.
This is unreported. You have seen it?
No.
এই যে দেখুন না, এখনই দেখে নিন। শেষ করে দিন। আর কত
Let it be taken up on Monday at 2 p.m.
Very well. Let him
Monday at
consider.
2 p.m.
He wants to consider.
Let me learn. Let me learn, my lord. I'm ready to learn.
All of us are learning.
All of us are learning. Till
My
father used to tell me,
my friend,
there is a
help me to learn. Therefore, I'm grateful to him.
Both of you help me to learn.
no.
As prayed for by Mr. Mondal and the advocate appearing for the petitioner, list this matter on Monday.
At 2 p.m. Kindly.
তাহলে আপনি মঙ্গলবার রাখুন, বুধবার রাখুন, বলে দিন।
ঠিক আছে, স্যার।
You want another day?
No, let it be taken up.
My 24, I am for the WBSCDCL in pursuance to the direction that affidavit, may I file my affidavit? But that matter was she is an advocate appearing personally.
Yes.
And
Milord, I am appealing for the, Milord, I am the petitioner in this matter. Milord, kindly direct them to serve a copy to me also.
already this affidavit has already been served by email on 10th of August. I have got the record. I've got the record. I can show from here that email has already been done to serve them on 10th of August 2026. Let us check that.
Your Lordship, maybe some network issues or something.
He has served you through mail.
By 10th August, I bear to mail.
Milord, may I kindly get it directly, Milord?
You have to hear then. You can't be at home and then expect it to be served on
Milord,
you.
I'm really very sorry. I'm very ill today. That's why I could not come. Milord, maybe by tomorrow I can collect it. I can take it from
Come tomorrow, they will serve on you tomorrow.
10,000.
Milord, kindly direct them to serve me, Milord, and kindly give me a reasonable time to give me reply.
For time, serve on him. Serve on her. When will you be available for it to be served on you?
Tomorrow, Milord.
Very good.
Affidavit
in opposition filed on behalf of the respondent WBSCDCL
But this is
authorities.
a mail. If your lordship kindly record that I have already served.
WBSCDCL authorities is taken on record. Full stop. It is submitted that a copy of the affidavit in opposition has already been served upon the petitioner through email. Full stop. The petitioner submits that a physical copy of the writ petition of the affidavit in opposition may be served upon her by tomorrow. Full stop.
Where I will serve, there is no.
The petitioner will be at liberty to request the learned advocate representing the WBSCDCL authorities to serve a physical copy when she comes to court tomorrow. Full stop. Time to file affidavit in reply to the affidavit in opposition stands extended by 2 weeks. List this matter 2 weeks hence.
Your Lordship, kindly 1 week, Your Lordship. I would make ready. The reply, your lordship, kindly 1 week. Earlier also it was 1 week, your lordship.
I is extended by 1 week. List this matter
Grateful.
on 2nd September.
Grateful, your lordship.
Mr. Miller, I am for the petition. But pursuant to your lordship's last order, ঠিক আছে বলছি তো আবার তো মুশকিল হচ্ছে my lord, last occasion, my lords, pursuant to my lord's order, my lord, I have served upon the respondent number 6 and 7, whose address was supplied. কোথায় সে অর্ডারটা কোথায়? Supplied by my learned friend. No, my lord, ঠিক আছে দিয়ে দিয়েছি. Yes, my lord, regarding this, my lord, I have preliminary point was raised by them that whether REIT is maintainable or not. My lord, I am not a party to the proceeding pending before surface yet. Now, my lord, I have been forcefully thrown to surface court, DRT court, because well, I am not a party in a proceeding. You are coming on all on a sudden and taking possession with the help of certain outsiders and the persons. And I am asking myself whether financial institution at all examined the documents or initiated the fraud intentionally. And financial institution is liable, very much liable, in initiating this fraud. And if fraud has been committed, if I can show prima facie, then REIT also maintainable and entire proceeding stands set aside. Your lordship will kindly take 2 paragraphs of a development agreement at page 33-34. Kindly, my lord. My lord has got it. My lord, my lord, clause 8. Sorry, first page, page 28, development agreement starts. My lord, clause 8. দ্বিতীয় পক্ষ তার নিজ খরচায় 19/1 সুভাষপল্লী বিটি রোড কলকাতা 1077 প্রেমিসেসভুক্ত মোট সম্পত্তিতে পাকা গৃহাদি নির্মাণ করিয়া এই চুক্তি অনুযায়ী স্বয়ংসম্পূর্ণ সেকেন্ড ফ্লোর এবং থার্ড ফ্লোরে 400 বর্গফুট কার্পেট এরিয়া সহ বাসযোগ্য ফ্ল্যাট 3টি প্রথম পক্ষের যথাক্রমে বিকাশ দত্ত ও গৌতম দত্ত বিপ্লব কুমার দত্তকে এবং তৎসহ প্রথম তলায় গ্রাউন্ড ফ্লোরের উপর 88 বর্গফুটের কার্পেট এরিয়া 60 3টি দোকানঘর প্রথম পক্ষ। দিস ওয়ে ফোর্থ ফ্লোরে 240 বর্গফুট এরিয়া সহ 2টি স্বয়ংসম্পূর্ণ বাসযোগ্য ফ্ল্যাট প্রথম পক্ষের অংশীদার শ্রীমতী ঘোষ এবং শ্রীমতী অনিন্দিতা নন্দীকে প্রদান করবেন। উপরোক্ত ফ্ল্যাটগুলি দ্বিতীয় পক্ষ প্রথম পক্ষের অংশীদার যথাক্রমে বিকাশ দত্তকে সেকেন্ড ফ্লোরে দক্ষিণে স্পেসিফাইড দি এরিয়া, গৌতম দত্তকে থার্ড ফ্লোরে, বিপ্লব দত্তকে থার্ড ফ্লোরে দক্ষিণে, রুমা ঘোষকে ফোর্থ ফ্লোরে দক্ষিণ পূর্ব দিকে এবং শ্রীমতী অনিন্দিতা নন্দীকে ফোর্থ ফ্লোরের দক্ষিণ পশ্চিম দিকে প্রদান করিবেন। This is the vital portion I have placed before your lordship. So it is specified the area of the building which should be provided to these persons. They are the owner of the land. And financial institution is granting loan, granting finance without going through the documents, without anything, without making any investigation at all, without examining the title of the property, and later on waiting for a long period, and you have approached before the DRT.
Mr. Moitro, this document which you are showing, page 28,
My lord,
Notarized document, it's not a registered
but
document.
to notarize, thereafter my power of attorney was registered. But that's true. But my lord, at least when I am showing the malafide and fraud, how they have the institution has, financial institution has committed, has indulged in doing such fraud. And when a fraud has been committed, at least, well, this is the read court. Well, where read court, of course, when there is act, alternative remedy is there. Even then, well, I can oppose the read court. If I can prima facie satisfy your lordship, that well, there has been fraud has been committed in by, my lord, conspiracy by the parties concerned there. I don't know whether others, by the parts and respondents are appearing or not. They will not. They don't know what has happened. And promoter is also absent from the very one day. Now, my lord, I am asking myself, my lord, if, my lord, proceeding has been, I was not a party, whether institution, financial institution was aware or not, whether examined the documents, who are the landowners, whether documents has been.
Is the development agreement power of attorney, what is it? Is power of attorney registered?
Yes, sir.
Does it have this clause there that what will?
And we have, but of course, there is one, of course, I tell you, lordship, this middle class family, they are not well acquainted how in manner promoter guides they are guided. It should have been, please let me finish. I'll finish. They are by a letter cancel the agreement, not the power of attorney. But I asked with I put this question to myself, and also I put them to why you have not taken any advice. And my lord, I find, if my lord, assuming my lord, if I go to tribunal, I'll have to deposit the cost, but as a portion amount.
No. For DRT, no, it is for appeal, not for
Appeal.
the proceeding.
And it will be, this will be now before the appellate authority.
No, it has to be before the DRT. DRT is usual court fee.
No, but they have. Now I will have to go against this order to tribunal.
Yes, so tribunal, there is no deposit required.
However, your lordship kindly see, my lord, I am, my lord, relying upon one poor. No, that judgment is to that guy. My lord, this is a judgment where some frauds were taken over, an entire house kept under lock and key. এটা একটু দেবেন, এটা একটু দিন না ভাই, আমি বলে দিচ্ছি, আমি এক্ষুনি বলে দিচ্ছি আপনার। এই কপি আছে, একটা কপি আছে বলে দেখো, এই জাজমেন্টের কপিটা জেরক্স কপি আছে, এটা একটা কপি ছিল না, এটা আমি তো দেখছি, দেখো এখানে আছে, এখানে আছে কিনা দেখো। My lord, I am coming to page 3, last paragraph. Yes, my lord has got one last but one paragraph. It would be a peculiar dichotomy if the respondent number 1 here, who is a financial institution carrying attorney, on business at a large scale, is kept outside the purview of judicial review under the jurisdiction of this court. And in the same breath, it is permitted on similar footing as public entities having a higher standard of transparency to take fullest advantage of the summary methods contemplated.
You consider this Shobha, this judgment was passed at a time when Shobha was not there. This is a recent Supreme Court judgment where financial institutions, even if governed by the RBI and the regulations, whether they fall under the writ jurisdiction or not, has been specifically commented upon by the Honorable Supreme Court. Taking
Oh, it
into
online.
consideration Federal Bank judgment of 2004.
There are several judgments, Your Lordship, starting from the Commissioner of Income Tax, where exceptions are given, where it can be entertained. This case does not fall within any of such exceptions, my lord. Moreover, there is a disputed question of
Federal
fact.
Bank was the special judgment for private banks.
Yes, in no, Your Lordship, I am Commissioner of Income Tax versus Chabildas, Your Lordship.
Chabildas was in respect
The
of writ
exceptions-
jurisdiction
Yes,
at
Your
large.
Lordship. Yes.
But so far as private banks
Yes.
is concerned, Federal Bank was the first judgment
First,
on point.
Yes, yes, my lord.
That was considered in Shobha.
And moreover, Your Lordship, there is disputed question of facts.
Question of facts, man, a disputed question of facts.
So far as maintainability of the writ petition, that is there in
But I will go through it. I am going through it.
Shobha, because this judgment was passed at a time when Shobha was not there. Shobha is subsequent to
Yes, it is subsequent.
This is 2020.
It is 24th January and it is one of subsequently, my lord.
25.
25. My lord, only my lord, I am showing my lord one observation of my lord, Supreme Court boicha daw. Just character copy দেবো দেখি। পিঠায় দেয় তো বার করো না। খুলে দাও এইদিকে দিন এইদিকে দাও কে এটা তো ট্যাগ মারা কেন আরে কোনটা বইটা দিলে
ঠিক আছে
দিয়েছো আরে ভাই আমার বইটা তো আমাকে দেবে ওফো
Central Bank is a public bank.
ইয়েস এটা আমি বলে দিচ্ছি 2025 4 SCC আর এটা হচ্ছে পেজটা হচ্ছে 38 আমি রিলাই করছি প্যারাগ্রাফ 48 অবজারভেশন অফ পেজ 38 at page 77 paragraph 48 well before we close this litigation we deem it necessary to observe that banks should remain very careful with inadequate title clearance report. I am, my lord, relying upon this.
This is right. This is right, Mr. Montro.
Right.
But before which authority will you urge this is the question. Will you urge this before the Article 226 court, or you will urge this before the civil court or the DRT?
Yes,
Because Central
before
Bank
the
and
my lord,
Sabha
title
was in the context of mortgage and negligence.
everything can be urged before my lord, civil court. And my lord, I am here, my lord, right to life, right to property. For that, my lord, at least minimum protection from this court, my lord, we can get. But we are nobody. We are absolutely outsider. We don't know anything. We are the owner of the land, and we have been kept in dark. And my lord, they have committed this my lord, fraud in league with those person. And I tell your lordship, my lord, those person will never appear before your lordship.
Your Lordship, even on
Will never appear.
my lord, those
And even I think, my lord, they have, whether they have appeared there, I can't say. They will never appear before this court. And well, same thing, man, the purchasers are not aware. Those purchasers are not coming back before lordship. This is the position where we will go. That's why we approached before this rich court that this is the problem, this is the conspiracy, and fraud vitiates every action, whatever may be. This is also a judgment of Supreme Court. My lord, may I read, my lord? Your lordship has read it, my lord, paragraph 40.
Yes, I have read it.
My lord, then I don't repeat, my lord. Next, my lord, I will place another judgment, my lord. I am telling, I will go through it. I am. দেখি আমার কাগজটা বলে গেল এটাকে কে নামিয়ে নিল আমার কাগজ ওহো নোটটা তো এখানে করা আছে হ্যাঁ দাও আমার বইটা আমায় দাও 21/6/771 দেখি 21/6/771 ও ফ্রডটা 19/12 এটা আমার 250 হ্যাঁ দাও 275 দেখো My paragraph, my lord has got it. This is, sorry, I mean, reference is 2019-12, volume 12, SCC, page 275. 2019, volume 12, SCC, 275. Paragraph 28, 29.
Yes. Paragraph 28.
29. 28 and 29. This is the case of my promotion. And well, after even after perhaps retirement, well, case was filed and it was held, paragraph 28. There is one or more reason for coming to the conclusion that the division bench of the High Court was in error in saving respondent number 1 on the premise that writ petition suffered from delay and laches. In fact, the association had submitted a representation to the then Chief Minister. Going by the nature of allegation, the Chief Minister rightly acted thereupon and referred the matter to committee, which after examining the matter had also given its report, stating that the promotion of respondent was against the rules. This provides reasonable explanation for delay effect. We are of the opinion that it was virtually a case of fraud, at least on 3 counts. First, by creating ex-cadre post. I am not reading those. This was I skip over few lines. 1, 3, 4, 5, 6. After 6 lines.
Last 3 lines. Fraud.
Last 3 lines. Fraud vitiates every action and cannot be kept under the carpet on the ground that the action challenge was belated. More so when there is a reasonable explanation for such delay. So here, at least I have been able to satisfy your lordship, my lord, that regarding my portions regarding development agreement, I admit whenever there are certain laches, certain fault, lapses, but admittedly this cannot be ignored by anybody. Of course, when in a suit, and when this has been placed, I don't know what has been placed, what was done. Financial institution, how could it loan? Paragraph 48, I have placed that judgment of 2025-4 SSC. That I have placed. 21-6 SSC. So, my lord, how bank can give loan to the persons without examining the title, without examining the papers at all? This is a fraud. And bank is, actually, this financial institution is indulging in frauds. Absolutely, with having full knowledge, and this is, a set-up proceeding before the TRT, because nobody appeared. Bank has gone and have made application, and all on a sudden, and we are in position. Bank has examined who are in position or not. I am granting loan without going through, without examining this, without going to the spot. Your lordship are aware when I don't need to explain. If even I purchase a car, then he will rush to my house for loan of mine, for sanction of 10 lakhs, 15 lakhs, 20 lakhs loan. And here bank is giving loan for few crores without examining anything. Is it believable? Without examining title, anything. Whether there is the existence of this person or not. Whether the applications are genuine or not. So, who? I believe, that is this is not a disputed question of facts only. There are certain facts also. But at least admitted position, this document cannot be ignored by bank, that it is not registered document. They have not considered this agreement. At least the documents, title, paper, porcha, or other documents are in our name. So I am granting loan to X without examining those documents. Definitely these documents was examined by bank. Thereafter, the power of attorney. This is a chain. This is a chain. This being done, where only, my lord, this court can save this, prevent this fraud, because lordship have enough experience what is going on regarding my lord fraud, committing fraud in number of cases, in many cases, in cases of appointment, in cases of loan, everything. So at least this is the duty of the judiciary to prevent it. And when I, with great respect to tribunal, I say, without examining anybody, he will not ask for the presence of the person. Where from you have got this ownership of the land? Your lordship asked me to serve notice upon those persons. They are not present before your lordship. So this tribunal will not ask the bank or ask the person to serve notice upon the landowners. They are in dark. On what basis they are granting loan? Which are the titles? I know this is the place there, but I am afraid about, with great respect, I am saying, my lord, about the conduct of the tribunal. Without examining any documents, I am doing this. And purchasing land by giving crores of rupees loan.
Yes.
At this point, we should have given a chance. Nothing. But if this person gets free from the court, why not gets the stump of the court, tribunal or anything, CJM or some judicial magistrate court from where, what is the order? We cannot examine even that. No. Paragraph টা কোথায়? দাঁড়াও, paragraph 27. ওইটা দিন তো। Yes, my lord, it starts from page, reference is, my lord, page 220, reference is 2021, 6 SCC, 771,
Paragraph,
my lord, 28, 27. Yes, 27. The power under Article 26 of the Constitution to issue writs can be exercised not only for the enforcement of fundamental rights, but for any other purposes as well. Well, I have alleged for a fraud. The High Court has the discretion not to entertain a writ petition. One of the restrictions placed on the power of the High Court is where an effective alternate remedy is available to the aggrieved person. Exception to the rule of alternate remedy arise where the writ petition has been filed for enforcement of a fundamental right protected by Part 3. There has been a violation of the principles of natural justice. At this matter, I can rely upon this clause B. C. The order of proceeding are wholly without jurisdiction or the validity of the registration is challenged. Now, we are not being heard at all. We were not given any opportunity.
You have not approached the DRT. You have filed.
I don't know. I was not aware, man. I was not aware at all.
Section 14 is not an adjudicatory proceeding. Section 14 proceeding, no.
After when we have come to know. We have come, if I place the petition, when we have come to know, I have stated there. When, my lord, the persons came with the police persons and other persons. Then, my lord, we were aware that some proceeding has been, they said that this proceeding has been initiated. Notice was
not a proceeding. That is just an application for police assistance.
They have taken out all these, my lord, belongings in the house. This is the fact.
Yes.
Number 27.6. In cases where there are disputed questions of fact, the High Court may decide to decline jurisdiction in a writ petition. However, if the High Court is objectively of the view that the nature of the controversy requires the exercise of its jurisdiction, writ jurisdiction, such a view would not readily be interfered with. My lord, this is, my lord, the facts I have placed before. They have not come with any, my lord, document that we were served notice at all. So, my lord, in this circumstance, my lord, at least, my lord, lordship will protect us for some time, if not possible, my lord, so that, my lord, we can approach.
Yes. Anything else? Any other judgment?
No, my lord, this is.
The maintainability of the writ petition has to be decided first, my lord, in view of several judgments, including SOVA, my lord. Private finance company, there is alternate efficacious remedy available, and moreover, disputed question of facts are involved here, which cannot be decided in writ jurisdiction, my lord. I humbly submit so, because mere pleading of fraud does not establish fraud. It has to be declared through a civil court. In writ jurisdiction, fraud declaration cannot be made. There are two subsisting title deeds, three rather, of two the respondent has not taken possession. One has been taken possession of. That even if there is fraud, the title deeds has to be cancelled by way of a civil suit. Until the time it is cancelled, the deed subsists, the right to the mortgage subsists, and right of the respondent to take possession of the same subsists, my lord, till the time it is declared as a fraudulent document, my lord. Moreover, my lord, on facts even, they are claiming something which they can be entitled to more than that they are claiming, my lord. Kindly come to their document, the supplementary affidavit, supplementary development agreement, which they have annexed from page 58, my lord.
Page 58.
Yes. Of their writ petition, my lord.
Yes.
Their allocation was, if my lord comes to page 60,
60,
my lord, the schedule of the owner's allocation is given. There are three supplementary agreements of three petitioners, my lord.
60? 60?
Yes,
Page 60. The 61 schedule is there.
Yes. So this Sri Gautam Datta is entitled to a flat measuring 400 square feet plus 200 square feet. That is 600 square feet only. On the north side
200, yes.
of third floor. Now the petitioner number 1, Vikas Kumar Datta, is entitled to, my lord, kindly come to the next pages. The schedule is given at page 65.
65.
Yes. One flat on the second floor measuring about 400 square feet plus 200 square feet, 600 square feet. So in any event, and there is another supplementary agreement, that too is also in respect of only 600 square feet, my lord. That schedule would appear at page number 70.
Vikas.
Vikas is at page number 65. And the third one is Biplab Kumar Datta. The schedule is given at page number 70.
Yeah.
So, Your Lordship, there has to be, if they are claiming fraud, had it been their case that on this particular 400 plus 200 square feet, the respondent is taking possession of fraudulent mortgage has been created, he could have substantiated his claim a little bit. But here the case is totally different. He cannot claim the entire building. My borrowers are having three separate flats, the area of which is one is 1800 square feet, another is 900 square feet, and the third one of which the person has been taken, that is also 900 square feet. So under any circumstances, this does not come up to their owner's allocation, my lord. So if their case is that
where is the notice that you have issued to them by which you are going to take possession?
Your Lordship, that I have got separately, 13 to 13 all notices were duly issued, my lord.
Notice should be also not served upon me.
Because you are not
On
borrower,
him, it
so you
cannot
will
be
not
served, my lord.
You will not be served. I just wanted to see the
Yes,
property
yes,
there.
yes, my lord.
Fixed parcel. All are fixed.
This is the entire document, my lord, starting from 13 to, and the question is also. Copy रखते बोले इसमें। সেটা করবে না, করতে হবে না, কিচ্ছু করতে হবে না, তোমাদের কিছু করতে হবে না। শুধু মামলাতে এসে কিচ্ছু করতে হবে না।
South side outside. Hey, because
I have also sought for title searching document from the respondent, my lord. If I can also produce the same if sometime.
Three different persons. Four. Because Gautam elected here. Because Gautam elected here. And at the Mohila is Ruma Ghosh. Four different persons. Allotment is also four, very different. Agreement are supplementary separate. Supplementary agreement is separate with each other. Mentioning the plot and side of the construction. Not for one person, but for not. কত স্কয়ার ফিটে আছে 600 কি আছে সবাই 600 কি আছে 1800
The flats are different.
Yes.
Then
how can he claim that I am taking?
No. This is one of the extra addition to that flat, that portion. But a portion of Gautam has been added, 200 square feet has been added to each part owner by supplementary affidavit. There are 3 supplementary affidavits, four supplementary affidavits, and my lord, this is what with the original portion mentioned in the development agreement. There 400 plus 200. Your lordship will find at page 60. Kindly look at page 60.
600 on different floors, my lord. How can this be same flat? What they are
Different
claiming?
floors.
They are claiming randomly everything.
Not everything. I have not claimed everything. I have claimed only my portion where we are living, and not more than this. Please, not more than 600 square feet to each of the to each person. Gautam, page 59. Look at between Gautam and Parthu. Kindly see page 59.
Page 59.
Yes. 60. Now page 60.
Now the
page 60. This is my north side. North side. North side. Area on the north side. Now your lordship kindly come to page 63.
64. Next page 64.
Between Bikash and your lordship kindly look at
65.
65 plus 66 plus 65 plus 66.
South side.
Oh, 65.
South side.
This is one self-contained residential 400 plus 200 on the south side. Different, all are separate. And page 68. Can you look at page 68? And
this is the Biplop.
This is Biplop. Next page 70. Page 70. South side. South side, 400 plus 200. That means the aforesaid owner will get an additional 200 square feet.
All three of your flats are on the third floor.
There is one on second floor.
One person is on the second floor. আর বাকি তিনজন থার্ড ফ্লোরে দুটো থার্ড ফ্লোর একটা টপ ফ্লোর ও one person in second floor আছে একজন
And your flat
one person is on the second floor.
First, second, and third.
Your Lordship, the position of which has already been taken is on first floor, which appears from page 77, and that area is 900 square feet.
First floor
That is on first floor.
First floor.
So we are nobody.
Which position has
We are not concerned with.
He is
No.
not concerned with first floor.
No.
I am not concerned.
The other two flats are, one is 1800 square feet, which is situated on
1500 square feet is on third floor. Third floor.
Lordship kindly, yes, 1800 square feet on third floor.
1500 on third floor, 900 on first floor.
Yes.
And another
And 900 on second floor. 900 on first floor, 900 on second floor, and 1800 on third floor.
third floor. Third floor আছে তাই তো
There are separate units what they are claiming as per the supplementary agreement. It appears
Mr. Moitra, if the finance institution is taking possession of an 1800 square feet flat, which is not your flat, how are you aggrieved?
No, which is not my flat. I am not concerned with that.
They are not taking possession of your flat.
They came. They have issued notice.
we have taken.
They have issued notice. They are suppressing the fact here. My learned friend is not properly instructed. They have
I am
suppressed.
going as
So,
per
Mitra, please wait. The papers show
Yes.
the flats of which the finance institution is going to take possession are one is of 900 square feet, another is of 900 square feet, another is of 1800 square feet. None of your flats are of 900 or 1800.
Which flat? Which portion?
Whatever portion. If the flat is of 600 square feet,
No,
it
yeah.
can match with a 900 square feet flat. Whatever be
My lordship will give me one. আমাদের তো করতে হচ্ছে 600 করে 600 করে তো বনেদেরটা 400 এই তো টপ ফ্লোরে যে আছে মানে these three persons are 1, 2 and 3 are my lord possessing 600 square feet each.
Yes.
And my lord fourth their sister Ruma Ghosh Anindita Anindita not here Anindita নেই তো মানে Ruma Ghosh and another sister, she is not before your lordship. One is here, Ruma, she is owning 400 square feet. 400 square feet on the top floor.
She is not here, so let us not talk about
No,
her because that is
Ruma
not-
Ghosh is there.
Subject matter is of the writ petition is not that. So we'll not speak of that. We'll speak of whoever is here. Now, total your flats are on the third floor. You have 600 plus 600, 1200. Only two flats are there.
My lord, I tell you, lordship, 600 square feet on the north of third floor.
Yes.
My lord, am I correct, my lord? He is Gautam.
Yes.
My lord. Next one. No.
Because
Bikash.
600 on the south,
Bikash.
on the second floor.
My lord, Bikash.
So, Mr. Moitro, let us go logically.
My lord.
On the second floor, you have a 600 square feet flat.
Yes.
On the second floor, they are going to take possession of a 900 square feet flat. How will the 600 square feet flat, even if they are on the same floor, match with the 900 square feet flat? One. Second, on the third floor, you have two 600 square feet flats.
Yes.
If I combine them, it comes to 1200 square
1200.
feet flat. They are going to take possession of an 1800 square feet flat.
Why?
How will the flats match?
It will not.
So
That's why I am telling your lordship, this 1200, number of fallacy is there. They are saying we have not touched their property. my lord, 600, 1200, and what they are claiming 1800 perhaps, 1800 total floor is, my lord, 1800.
They have a flat of 1800. It can't be
No,
floor.
no,
Yes,
no.
That is their schedule.
Title deed is there.
That is the schedule. The title deed is there.
No, man, that is not my. Let them disclose it, man. I let them supply the documents, man. We have not able to get any copy. Let them supply the documents.
You are not the borrower. You are not the borrower.
No, man, but they are touching my property. I don't stand in the way. The persons who have taken loan, you proceed against them. We don't stand in the way. But the problem is this: where we are deciding, which is allotted flat to us, including supplementary period, was specified 600 square feet. This portion occupied by us on the floors, they are claiming.
What is your instruction on the area? Is their area being included in your flat that you have
Yes,
taken?
that I will come back. I can come back. with
Take
those
instructions. If we can solve it on factual level, we'll do.
Right.
Otherwise, we'll decide on maintainability aspect.
Yes, look.
Right.
Because maintainability, we have to decide. If it
Yes,
cannot be
madam. That
decided
has
like
to
this,
be
then we have to decide on maintainability. But if it can be sorted out this way, then
Yes,
we'll
yes.
go that.
My
When can we have it?
Any day next week, my lord, I'll come back with instructions.
When, Mr. Moitro?
Next week, next week,
Next Thursday?
Yes.
But let them give a copy in advance, if they.
Let her first understand, because you may not be entitled to this. I will also not be relying on this, because I will have to first cross maintainability hurdle and then come to this.
Well,
I'm
next.
trying to see if we can find a way out.
Yes.
If you are a genuine flat owner, you should not be disturbed.
Man,
Although
that's why only I don't stand in the way. If anybody has taken loan, let them suffer.
heard
I'm asking for the applicant, my lord, is for the letters of administration, my lord. Escape for issuance of citation, my lord. And on the last occasion, my lord, if your lordship remembers, 17 July 2026, your lordship passed an order to cure all the defects within 2 weeks. We have cured all the defects. There is nothing left to be cured, my lord. Now the citations may be, my lord, direction be passed to issue.
An application for
my application, my lord, for citation, my lord, the one of the daughter is the executor, one of the daughter give consent, my lord, another daughter not give consent, my lord, and my lord, the son's my lord, brother was died, my lord, so his wife and the two daughters, my lord, not give consent. My lord, I stated in my lord, I have already deposited the court fees, my lord, so my lord, the court fees are not postponed, my lord.
is an application for grant of after the completion of citation. Same citation.
Yes, my lord. Just one thing I must indicate. Well, out of the two attesting witnesses, one has died. So, my lord, his death certificate is also there, and the affidavit by the other attesting witness is also annexed to the application. Citation may be issued, my general citation as well as, my lord, paper publication, if so direct.
So this is an application for
So therefore, my lord, the whereabouts of any legal heirs by abundant precaution, I'm applying for citation as well as publication, my lord. General citation as well as publication.
this is an application for grant of probate.
A, my lord.
And for the executor, my lord, I pray for issuance of special citation, my lord.
Begin.
Prayer in terms of B, C, and D, my lord.
This is an application for grant of probate of the last will and testament dated 5/2014. Full stop. The heirs, legal heirs of the deceased have
As I have stated in paragraph number 6, he is the elder daughter of the deceased and general citation. There is no consent.
This is an application for grant of probate of the last will and testament dated September 18, 2020, left behind by the above
my lord. The husband also expired prior to the, my lord. I'm praying for a general citation be issued by the department through paper publication. Direction may be given by.
This is an application for grant of probate
My lord,
of the last will,
a matter is going on before court number 6, my lord.
last will and testament dated January 15, 2020. Let this matter go out of list. তো হলো।
Wait, please, my lord, this is my probate application. There's also an interlocutory application appearing in the list, my lord. I'm not pressing that application. It was only to, my lord, bring on record the law, my lord, that has now been settled by the division bench of this court. My lord. Tier 1 actually amendment. Tier 1 was for amendment of affidavit of assets, my lord, that has already been allowed.
Amendment has been carried out.
Yes, my lord. Amendment of the affidavit of assets have been carried out.
দেখিও এই ইয়েটাও দিয়ে দিন না, জিএটা এর সঙ্গেই এসছে। All have consented.
Yes, my lord. I am, my lord, a son, my lord. The other two heirs, my lord, that the other two sons and the daughter all have given their affidavits of consent. My lord, I am the executor and the sole beneficiary under the will.
Where are the consents?
My lord, the first heir being, my lord, the daughter, that's Indira Prasad Gupta, my lord, that affidavit, my lord, your lordship will find at page 40.
Page 40.
The next heir would be, my lord, Rajendra Prasad's son.
Yes.
Yes.
Yes. Page 40. Next.
Well, the next heir, my lord, would be Rajendra Prasad's son, my lord, of the testatrix, my lord. That your lordship will find at page 75.
Page 75.
Second.
Yes.
Well, the third heir, my lord, is Rameshwar Prasad, another son, my lord. That your lordship will find the affidavit at page 110.
Rameshwar Prasad. And Gopal Prasad is the executor.
Is the executor, my lord, and the sole beneficiary. Also a son, my lord, of the
And
district.
attesting witness. Attesting witness.
My lord, the attesting witness affidavit, your lordship. এটা কি এটার সাথে অ্যানেক্স করা আছে? কারণ আমার এটাতে এরকম ভাবে আছে। হ্যাঁ। My lord, that's should be possibly, my lord, not numbered. That's Abhishek Tiwari, my lord, one of the affidavits. হ্যাঁ, separate ছিল, ওই জন্যই। Thank you.
Yes. লিখে নি।
I'm one of the sons. No objection received from my mother and my brother, Lordship, and I'm seeking.
Illegal heirs, two have consented.
Yes, Your Lordship.
And one is the applicant.
One is the applicant, Your Lordship.
Without will.
Without fee, I'm.
The will annexed.
Yes, without the will. Lordship, only one humble submission and request, Your Lordship. It is the main property is a cooperative flat, Your Lordship. If the bond amount can, Lordship, be kindly looked into. They are not into much good financial condition, Your Lordship. It's a letters of administration, so there has to be a bond amount furnished.
The value.
Lordship, the value is 50 lakhs due to a cooperative flat, your lordship. That is the main property that is coming under. So the value is 50 lakhs, your lordship, of the flat cooperative society. So lordship, if kindly, it is a fixed asset, but they are not in much liquid asset with them. Lordship will kindly consider while granting the bond amount, lordship. That is a humble submission.
I can make 2 instead of 1 surety. That will divide.
Lordship grants 2 surety and lordship grants, lordship will look into the bond amount, lordship.
How much
I'm- I-
will I do? I can't go beyond limits. It won't look nice. There तो 5,000 টাকা লেখা আছে।
Lordship, in many cases, Lordship, as per the practice in some cases followed during the last some years, Lordship, is that even undertaking furnishing has also been accepted by this honorable court.
You have orders.
Lordship,
You have those orders. Show me.
Lordship, I can bring those orders.
Take
Justice,
them. I'm making it not today. Monday. you
I'll
make.
bring those orders. I'm deeply obliged, Lordship. I'm deeply obliged, Lordship.
Petition. In this matter, the gentleman died at Haryana, leaving a wife and aged mother. Father has predeceased him, and 1 daughter and minor son. Has been made on 16 January 2019. The testator died on 3rd March 2024. And
All have consented. Everybody has consented.
everybody. And the mother who is one of the witness in the will, he has affirmed the attesting witness as an attesting witness.
জাস্ট একবার দেখে নি, তারপর একটু বসে যান, জাস্ট একবার দেখে নি উইটনেস গুলো।
I have deposited the entire stamp duty of 50,000.
But where is the consent of the daughter?
Daughter.
All the consents are not here.
Yes, madam.
I only find the consent of the wife.
Daughter's consent, your lordship will find just little later. Affidavit of consent of Atul Preet Singh that a wife should. Shahiba Pal daughter. Shahiba Pal.
Yes, but her consent is not there. Where is the affidavit of consent?
In my copy, in my brief, I have.
No, I have to have it in my record.
That is
I have 2 consents in the name of the wife.
And the mother has also given consent.
No, I don't have neither the mother nor the daughter.
Then kindly take up the matter in some other day.
Consent of the minor son will also have to be given by the mother. That also is not there. So you need 3 affidavits of consent.
Minor son's affidavit was also done by the mother, natural guardian. My lord, in that event, kindly adjourn it. Let me find out from the.
Adjourning it for a week. Not this week. Not this week will do, or you want 1 week?
1 week. 1 week.
1 week. As prayed for, list this matter after a week. Please check the records. I don't find them.
I will find out. Try to find out.
Let this matter stand adjourned for a week.
This is my application. मतलब disease has 2 years, मतलब mother 3 years, मतलब wife, daughter and son. मतलब wife has applied for probate. She is the executor. Daughter has not given consent, and son has not given consent.
Mother? Mother?
No, mother died long ago. That has been stated in paragraph 6.
Paragraph?
Paragraph 6. And son has not given any consent. Citation issued, no caveat was filed.
Son has not given consent.
No. Caveat issued, citation issued, no caveat was filed.
Son not give. Daughter has given consent.
Yes, it is annexed. This is here. After the affidavit of attesting witness, daughter's affidavit is consent affidavit. And I have also obtained no caveat certificate.
Why notary consents, madam? Why notary consents? Give consents from this before the oath commissioner. 2 weeks as prayed for by the petition.
My lord, petitioners before your lordship, my lord, are wife and daughters of the deceased, my lord, is seeking letters of administration, my lord. My lord, if your lordship takes my application,
Yes.
my lord, the deceased, my lord, died on 7th February, my lord, 2024. And my lord, leaving behind only daughter and wife, my lord, the petitioners before your lordship, my lord.
Both have applied.
No,
They are the only legal heirs and both
they are
have
the only
applied.
legal heirs.
Both have been appointed as executors.
Yes, yes.
Oh, you want letters of administration?
Letters of administration, yes. Total value of the assets, my lord, stands after amendment, my lord, is at page 1, my lord.
23.
Yes, 1 crore 23.
Surety won't be this much only. Surety has to be more. Be 10%.
My lord, whatever your lordship please.
This is an application for grant of letters of administration.
All the legal heirs have given their consent affidavits.
Where are the consents?
Consent, it's unnumbered, your lordship.
Unnumbered. Okay.
It's annexure
Anyway,
C.
I'll go through.
The first one is of her husband, of the deceased husband, and second is the daughter, and the third is the eldest son.
This is an application for grant of probate of the last will and testament dated August 8, 2020.
Blood 17, my lord, kindly permits me to appear virtually, my lord. I appear for the petitioner. In this case, my lord, this has come after the issuance of citations. And my lord, today, my lord has the affidavit of consent of all the legal heirs who are mentioned in the probate application, my lord.
All of you are appearing.
I was brought in as the backup counsel. The main counsel is there.
Who is there as the backup counsel? Oh, then, my lord, I'm being led by him, my lord.
I am not. Mr. Alim is there in the
This
matter.
will make it suspicious.
No, my lord, Mr. Nayak is leading me, my lord. I was not. Though I can't see the other side of the screen, my lord, but Mr. Nayak is leading.
So many counsel in a contentious matter makes it contentious. Very well.
Your
Show me
lordship
the-
kindly grant me. Yes. My lord, Mr. Nayak, kindly please show me, or else I.
No, they are all separate. He will not be able to assist. I will have to go through. They are not annexed to the
Lord,
application.
yes, my lord. That is what I wanted to point. My lord, just one indication. Your lordship will find that the affidavit of consent of, Lord, there are three legal heirs, Kalpana Das Mahapatra and Kishore Nandan Mahapatra, Lord, were filed along with the probate application. Subsequently, affidavit of consent of Shriya Adhikari was passed. Lord, was for the records. So, Your Lordship, these three affidavit of consent are there. Lord. And Lord, the will has been proved by the attesting witness.
I have found Shriya and
Yes, my lord. Shreya Adhikari was filed subsequent, my lord. On 5th of May, my lord, it was filed. Shreya Adhikari.
Shreya Adhikari.
Confusion হচ্ছে
বাকি তো attesting sorry একটা consent পেলাম
Blood consent is there of Shreya Adhikari and blood the
Shriya Adhikari, you have filed it separately or it's annexed?
yes, blood separately, blood. It was not there at the time of probate petition.
Yes. All three attesting witnesses have affirmed affidavits?
Yes, my lord. Yes. Yes.
Civil.
Yes, my lord.
And what about the mother of the deceased?
Mother is
My lord, mother is pre-deceased, my lord.
Oh, okay. Yes. Where have you mentioned that, Mr. Ali?
My lord, just kindly gives me a moment. This there. Certificate. Death certificate. Death certificate. My lord, that fact, though, my lord, is not mentioned in the.
But that's
But my lord,
required. If she is alive, she would have been one of the legal heirs.
yes, my lord, your lordship is right. But my lord, the fact is, my lord, that is
It on
not.
record, Mr. Ali. I cannot presume that.
No, no, my lord, I'm not asking my lord to presume. I'm just, my lord, your lordships may kindly take our word, my lord, that the mother has predeceased, my lord.
You file a one-page supplementary, bring it on record. What is the problem? I'll do it.
Mother has passed away in early 90s, your lordship.
Where is that before this court? That you are submitting now. You should have brought that on record. Is there anything mentioned in the will?
Lord, may just
Where it
kindly
can be
give.
made out?
No, my lord, it's not there mentioned in the will. Only the fact that the father has passed away, my lord, that is mentioned, son of late Aditi Nandan Das Mahapatra.
Yes,
But,
that I
my lord,
understand. But that is an important line which you should always have.
yes, my lord.
This, my lord, I'll have to take responsibility. I'm the one who drafted it. But my latches on my part, we were.
Bring a one-page supplementary, that will do.
My lord, with leave of my lord, my learned senior, your lordship may kindly passes that direction. We will file a supplementary affidavit. That will help us.
As prayed for, leave is granted to file a supplementary affidavit. Full stop. List this matter after a week.
Extremely grateful, my lord. Extremely grateful.
That's important.
That is because it's a class 1 legal error. Has to be,
Yeah.
my lord, pleaded properly.
Either you plead or you show it in the chart that she is alive.
I didn't do it because she died, my lord, in the night.
I can make it out.
It didn't strike
But
my.
sitting here, I cannot presume anything.
Naturally, my lord.
It has to be shown in black and white to me.
Very well.
Presumption only in terms of Evidence Act. 30 years from then, there are a lot of facts will be required to show. If you can show that from the last act done by the person 30 years back and 30 years have passed, then in that case presumption of death can arise. But then also these are all rebuttable facts. Lot of things will come. Put a one-page supplementary, get rid of it.
This was purely more a lack of experience, my lord, which is why it's absent.
One day I found in one of the affidavits of attesting witnesses, it was not written sound mind, good health. There is no proof then.
Which is why, my lord, in the solemn form, it's slightly, my lord, difficult unless the witness really goes up on the docket.
Yes, but then if you are proving it by common form and in the affidavit you don't write this, what
the advocates, when we are doing the chief, we can breach the latches, but great.
গো আউট করে দিন, আর নেব না। আর এগুলো যেগুলো গো আউট হচ্ছে আর লিস্টে আনবেন না, ফালতু ফালতু। হ্যাঁ হ্যাঁ, ফালতু ফালতু লিস্টে আসে তারপরে।
Your Lordship, I am appearing on behalf of the sole executor. I'm appearing on behalf of the sole executor.
Item 19.
Yes, yes. This is a petition seeking grant of probate of the last testament and will dated 17 January 2022 of the deceased Saintly Mohit Agarwal. Your Lordship, the execution of the will has been duly attested by two witnesses, and the affidavits of the attesting witnesses have also been annexed to the petition.
All the heirs have consented.
Yes, Lordship. There are four legal heirs of the deceased. One is the mother, one is the widow wife, and two minor. On behalf of the two minors, the mother herself, and on behalf of her two minor children, has given the affidavit of consent.
You please come back on Monday.
Lordship.
একটু দেবেন তো জয়েন্ট অ্যাফিডেভিট বলে বাচ্চাদের জন্য হয় না 1930 একটা জাজমেন্ট দেখছিলাম দেখে বলুন নেক্সট
Your Lordship, this is my application for grant of probate, Your Lordship. The testator made a will in the year 2015, January 12th, died on May 13, 2015. The testator is survived by his wife, 3 children. The daughter is the sole executrix, and 2 sons are there who have given their consent. All the legal heirs have given their consent. And mother and father of the testator predeceased. The Lordship, page 5, para 10, the list of legal heirs are mentioned.
mother predeceased
Yes, mother predeceased.
mentioned
Yes, mentioned, and also reflects in the death certificate. And both the attesting witnesses filed their affidavit of death.
This is an application for grant of
Attesting witnesses are also given their consent.
in the affidavit of the attesting witness.
Which one? There are two attesting witnesses, Sugato Ghosh and Sujoy Sengupta.
Yes, please see the affidavit. Sound mind, good health, where is that? Testamentary capacity.
My lord, kindly sees page 2, paragraph last line, my lord. Paragraph 2's last line. At the
Yes.
time of execution of the said will, the testator was of sound mind.
Yes. लिखे नहीं. This is an
administration, my lord. The deceased died intestate on 11th of December 22, sorry, my lord. On 3rd of March 2024. Now, the applicant is the sole legal heir. Your Lordship kindly takes up, my lord, paragraph 6 and 7, page number 3 and 4, my lord. Son of the deceased. The wife and the mother both have predeceased, my lord, the deceased. Here, my lord, we made that pleading. That pleading, my lord, in the previous matter, what was missing is here in paragraph 7.
Yes, because you are saying you are sole legal heir. So yes, surety can't be 10, 6 crore.
The only reason we took that indulgence, my lord, with my lord's leave, I'm making the submission, sole legal heir. That's the only reason. There's nobody else, admittedly. He's the only son. Mother has died, grandmother has died, both prior to the father's death. That's the only reason we took
Then
this.
why do you need? You have shares.
Shares.
So you need.
Yes. Several shares. Valuation, my lord, I'm told, my lord, is some point, my lord, was in crores, which is precisely why this application. Affidavit of assets we've disclosed, my lord.
Yes, I've seen that.
Disclosed it.
Seen that.
Only, my lord, with respect to the bond, my lord kindly considers. Only on the otherwise, my lord, I would not have made that prayer. So only on the ground they are sole legal, only son, my lord.
How much can I reduce? It will come to 60 something. Yes, 10% is that.
But the instruction that's coming, my lord, afterwards, Colin Fray will have to embarrass to submit in court. Lordship kindly, my lord, restricts it to this, my lord. The amount
Let it come on Monday. I'll think over it. Monday. অত কমানো যাচ্ছে না।
Order the anything. Lordship, please to pass some order.
Very good. List this matter on Monday. ওটাই লিখে দিন দিদি, ওইটাই লিখে দিন।
I'm deeply obliged.
My application for letters of administration. In this matter, my lord, there is one legal heir, the only wife, Carla Hermine Daga. She stays in Germany. We have served the citation. The last order, this is the last order, my lord. I have served the citation, but she is not, she didn't file any caveat till now. So kindly probate be granted in the
Caveat service certificate, yes.
Yes, my lord, is there.
The executor died.
The executor died. Then we filed the letters of administration, and then in the meantime, citation was cited, but nobody contested this.
What is the value of the assets?
My lord, value of the assets is is 3,55,44,221.
So, surety,
Sorry, my lord.
surety, this bond,
My lord, bond. Nobody is contesting. The only legal heir.
there is a legal heir,
There's a legal heir, but she is not contesting.
maybe still. I usually grant 10%.
Yes, yes, ma'am.
लिखे नहीं.
Bond.
This is an application for grant of
I am appearing on behalf of the executor, Your Lordship. Registered will, no children out of the wedlock, predeceased wife. Legal heirs are one brother and two sisters. All of them have given consent in favor of the nephew of the executor.
They are still alive.
Your Lordship.
They are still alive.
The executor,
No.
the beneficiary.
Yes.
Beneficiary is alive, Your Lordship.
88 at the time of grant of consent.
All are alive, Your Lordship.
Where is the consent of Geeta Devi Bhattar?
Your Lordship. The third consent is of Gita Devi Bhattar. The third consent, Your Lordship.
ये थे notary ব্যাঙ্গালোর ও ঠিক আছে ওখান থেকে আর this is an application for
for the petitioner. I file a restoration application.
Dismissed for default.
Dismissed for default, which I have mentioned in paragraph number 4 and 5 in my petition. The erstwhile advocate died, and the incident of death of the advocate came from the learned clerk.
This is an application for restoration of
Item number is 39.
For the caveator, and he has
he is praying for time.
Yeah.
discharge of
Item 39 है लिखे नहीं as prayed for by the learned advocate appearing for
Delhi, Your Lordship, and the mother is a very elderly person, Your Lordship. That is why, Lordship, the
but the affidavits are in are of Kolkata.
no, Your Lordship, it's Lordship kindly granted, Lordship.
39.
फिर भी